Right. Share market
Today is not the mentioning date. Yes, call the list. But only unlisted. I will take
unlisted.
Unlisted. What is unlisted?
Well, tender matter. Well, the bid opening date is on Monday. Well, we have got to know. Well, yesterday and day before. Well, we have prepared the rate. This with Lordship and recall 2 days back. Lordship was dealing with a matter of DVC, Damodar Valley Corporation, where the arbitration was ongoing, and they floated a tender inducting third party. Well, they have floated another tender, and by cause of action, well, it is released to the new one. Lordship may kindly seek to move the matter on Monday. Well, if your Lordship give some preference to the matter. I'll serve notice today.
Within 10 minutes.
My matter is also not in the list, but there is an extreme urgency, my lord.
Monday or Thursday? Only mention Monday, Thursday. No. Yes, call the list.
Lordship, I am staying for leave to file a supplementary affidavit.
Sorry. Yes, call the list.
Lordship, the matter may not be taken up, Lordship.
Yes, next. Who is the number one?
I have for the petition, Lord. It's a remarkable situation, my Lordship. Kindly first take the tender terms. My Lord, it's at page 38. What I would like to show, which 30? Is the yes, my Lord, page 38. Term of the tender, clause 3. This is the e-tender notice, my Lord.
Yes.
Clause 3. My Lord, completion period of the work is 24 months.
Yes.
Now, my Lord, pursuant to my Lord, this tender, I was declared as the successful tender, and my Lord, the letter of acceptance was issued on 25th of April, 26.
Where is the letter of acceptance?
Yes, my Lord. Letter of acceptance is, my Lord, at page 312.
3?
Volume 3, page 312. Before that is, my Lord, the standard conditions of contract and the general conditions of contract. Volume 3, my Lord.
312?
Yes, my Lord.
Yes. When it suit?
Letter of acceptance, my Lord. Well, the terms are there, my Lord. At page 313, my Lord. The Lordship is pleased to turn over to. The completion period is indicated 24 months.
Yes.
Lordship, the last sentence. I'm sorry, the penultimate sentence at page 313, my Lord.
Yes.
The entire work shall be completed within 24 months from the date of issue of the letter of acceptance.
313?
Yes, my Lord. The first paragraph. It's a
entire work, yes. Yes.
Now, my Lord, 19th May 26, my Lord. Which is at page 383. 383. In between there, the correspondence exchange of WhatsApp messages, where, my Lord, we have indicated the progress. But the initial progress would be, my Lord, submission of the bank guarantees, which is undisputed. We have put in the bank guarantees. We have initiated, my Lord, the steps which are required to be taken for the purpose of completion of the contract. 19th May, they request us, my Lord, submission of bar chart.
Yes.
Again, a similar request on 25th of May 2026, which is at page 384.
Not yet commenced. Therefore, it is
that is their statement.
Immediate necessity action against commencement of the work. You start the date without any. Yes. Then,
my Lord, 384 is 25th of May. Video above reference, it is hereby informed work is planned to be executed in a phased manner. Accordingly, materials are required to be procured in line with the phase-wise execution of the work. In view of the above, you are requested to submit a detailed bar chart indicating the work progress schedule. Procurement of materials and issuance of call letters will be decided based on the submitted bar chart. Then, my Lord, 1st June 2026. Despite repeated reminders via above references, the bar chart for the work has not yet been submitted by your firm. Furthermore, 1 month has elapsed since issuance of letter of award. However, work has not commenced. In view of the above, you are hereby advised to submit the bar chart immediately. 4th June, my Lord, again a similar letter at page 386. They say, my Lord, with reference to above, it is hereby informed that the target for execution in the year 2026-2027 has been fixed at 15.25 kilometer. Accordingly, following commission milestones shall be achieved. So, my Lord, they set out the achievement, the milestones which needs to be achieved by the year end of 27. The detailed bar chart submission incorporating the aforesaid, my lord, has also been called upon. 387, we submit the bar chart.
Yes.
387, 388 are the bar charts. My lord, 389 is 4th of July 2026, which shows, my lord, we have applied for, my lord, submission of cable route plan. All of this is preceded, my lord, by our initiation is preceded by the RFQ, which we have placed on the vendors for the purpose of getting quantities. My lord, the documents are there at page 376, which shows the email. 376 to 378, my lord, there are WhatsApp communication between, my lord, the respondent and us, my lord, between 378 and, my lord, 382. So bar chart submitted, the cable routing plan also, my lord, we have indicated. 390, 391, my lord, purchase orders which we have placed on, my lord, the vendors are at page 391. 391, 393. June, my lord, at page 395.
Yes.
My lord, 29 June at page 395, my lord, we submit the bar chart with reference to subject matter above. We are submitting the bar chart of the project. We have issued the purchase order of cables for the entire project. Call letters will be issued of cables till July 10. NSDAC and UFSBI call letters will be issued till 25th July. We will be executing the works as per the bar chart. My lord, and my lord, these are annexed.
Yes.
396, 397, 398, up to, my lord, page this is up to, my lord, 412. Now, on 1st July 26, my lord, the issue a letter led by Mr. Chaudhary, my lord.
Yes.
I'm very sorry for being late.
Yes.
Unprecedented traffic today.
Yes.
Milord, complete, Milord, high-handed exercise. My
What has
learned
happened?
friend-
What is the order?
Milord, that, Milord, page 431. Looks innocent.
Notice of termination.
Yes, 14 July 26.
Hmm.
Contract, Milord, starts on 25th April 26.
Hmm.
So, Milord, 2.5 months.
Hmm.
Now, Milord, 5 things I want to tell your lordship.
Hmm.
It's not for any urgency of the railways.
Hmm.
I can understand the line is getting stuck.
Yes.
First, Milord, thing is LOA 25th April.
Hmm.
Now, lordship will be surprised to note that that my bid was accepted
Hmm.
in February,
Hmm.
19th February. So February to April, they don't issue the LOA, they wait.
Hmm.
Now from April, so if there was real urgency, they would have done it earlier.
Hmm.
Second, most important, this is not a milestone-based contract.
Hmm.
Lordship has, my lord, seen the allegations. I can understand there is no allegation that you failed to act in terms of the milestones.
Okay.
My lord, kindly come to page 431 once.
Yes.
Issue of letter of acceptance for the work on 25th April. Multiple communications were made to you regarding submission of bar chart, etc. Then no physical work has been started. Then 48 hours notice was given. So, my lord, what are the two allegations? Allegation number 1, is submission of bar chart, and allegation number 2, no physical work to be done. My lord, please have a look at the bar chart once at 415. This is yet to be approved by them. Now, my lord, please see 415. This is what will tell your lordship what is going on.
Yes.
My lord, please see on the left of the page, it's slanted, so on the top, your lordship will find serial numbers 1 to 26. And then, my lord, on the right, 1, 2, and 3. My lord, there are 24 columns. That's the 24 contract months. In 1, 2, and 3, that is 1st May to 31st July, your lordship will see that only for site survey, building completion is
This was approved.
no,
This bar chart was
no,
approved.
no.
Hmm.
They didn't get the time to do it.
Hmm.
Bar chart is also not approved.
Hmm.
But even if you
And
follow,
when you submitted this bar chart,
this bar chart was for the first time submitted. Please, একটু আমায় তুমি করো 22nd, Milord, 9th of June, page 379 is the WhatsApp communication. Then the response is that as per target, you please submit.
correct,
22nd June, it's submitted.
correct.
They say that give it by Excel sheet. 24th June, it's submitted. Milord, thrice it's submitted, never approved.
Hmm.
Now they say that I don't work. Milord, please see. Milord, please come back to the bar chart once. Please see what is the work which I have to do. I have to do number 1, which is serial number 2, site survey,
Yes.
and serial number 10, which is design and preparation.
Yes.
And that's all that I really have to do. Otherwise, the third thing is building completion work. This is, my lord, one small building at a station, small room for housing, my lord, whatever I'm putting in. What I'm putting in, my lord, is this. After, my lord, every traffic signal, we are going to put in some form of a mast, which will, my lord, count the number of wheels which go by. So once you have this whole thing set in place, and it's connected, my lord, through cables to, my lord, their system. Now, once they have it in place after 24 months, my lord, you know exactly whether the train has gone by or not, because the machine, my lord, counts the wheels. And then what you can actually achieve is there is a distance maintained between trains, so you shorten the distance between the two trains because you know exactly what has gone by. So 3 things. Number 1, I have to put in that mast. Number 2, I have to connect it with cables. And number 3, there is a small room at the station. When they approve the plan and give us the plan, we make that to house the main equipment. So, my lord, first thing you do is survey, site survey, which is serial number 2.
Yes.
It starts in the 2nd month and it finishes in the 11th month. Please see, my lord, serial number 2.
Yes.
Now, what have I done? There are, my lord, 15 segments. In 1.5 months, even though I have 11 months to do this, 2 to 11, in 1.5 months, I have completed, my lord, 7 out survey of 7 out of 15 segments. And I have, my lord, submitted the reports, which are, my lord, at page 387. Second is, on this survey, you submit final drawings. So I have, my lord, I would have to submit 15 drawings in 11th months. I have submitted the first drawing and I have completed, my lord, 7 out of 15 surveys. That's, your lordship would find that page 387 onwards. And the drawing is at...
Yes.
Then, my lord, what is very important, this entire 44-kilometer stretch should have cables. I have purchased the entire cables by issuing 2 purchase orders, which is, my lord, at 391, 392, and 393.
Yes.
and I did this on the 16th of June. RFQ for the purpose of purchasing this equipment was placed, my lord, on 12th of May 26. May,
Yes.
my lord, page 376.
Yeah.
And 19th May at page 378.
Hmm.
So, my lord, if I may summarize, I am exactly in time with the bar chart which I have submitted.
But the bar chart is not approved.
So, my lord, if bar chart, I am grateful for the question, because if bar chart is not approved, I want your lordship to see page 38. Now, serial number 3.
Yes.
Completion period of the work is 24 months.
Correct.
And the same thing your lordship would find at page 313, which is, my lord, in the LOA.
Yes. That has shown by Mr.
24 months.
Ghosh has shown that. Yes.
So, my lord, 24 months I have. There is no milestone. I am ahead of my work. I am ahead of my work in 2 months. Now what happens? Now please see, my lord, what happens. First is, I start receiving constant emails and letters asking me to, my lord, please come to bus 383.
Yes.
19th of May.
Yes.
19th of May, page 383. Submit bar chart. 25th of May, submit bar chart. Unless I do visual survey, it's not possible. And we have just started the contract in April. Give me a month to finish the survey. Until I have some procurement promises, I can't give you. So, my lord, there are 4 emails. 19th May, 25th May, 1st June, 4th June. 4 letters asking me to submit.
Yes.
9th June, I submit. That is 379.
Yes.
Now, please see at the top. This is, my lord, given to the respondent number 5 who is terminated. Deputy CSTE Kolkata. My lord, I submit at 12:52 p.m. Then he sends me target for 2026-27 for auto section renewal. And says, please submit bar chart as per target given to railway board. So he's given a target to railway board. He wants me to align to that. So I do that. And so I say, sure, sir, and submit again on 17th June. Now, on 22nd June is the formal submission. Page tab, I forgotten to note it. 22nd June is the, Lordship would kindly forgive us. This one letter in haste, my lord, I have referred to, but I have not annexed. Forgotten to, my lord, put it. Kindly see this. And this is updated. For first time I give by WhatsApp, this is updated. Please find the attached file. We have updated as per your advice, 22nd of June. Now, 24th June, my lord, they write back saying submit in Excel format.
Yes.
My lord, this is the email, my lord, submit in Excel format. And they say that no activity. How can there be activity? There's no procurement completed. There's no survey completed. I have 3 months to survey. I have 24 months to complete. So, my lord, we give this. And importantly, RDSO approvals are needed.
So how the writ code can enter now? It is
Now, my lord,
how the writ can be entertained?
there's no arbitration clause.
There's no arbitration.
No arbitration clause.
Where is the arbitration?
My lord,
There's no agreement.
please come to page my lord, 251. No, I have to go somewhere. They designed the arbitration clause in such a way that termination is not arbitrable dispute.
Why?
63, my lord. conciliation of disputes. This clause is applicable to tender having advertised value of less than or equal to 50 crores. I come within 63 because it's 40 something crores. 63.2 is 50 crore plus.
What is your tender value?
43 something.
So that is not more than 50 crore. So
So this is
63 will not
less or equal to 50 crores, not 63.1. Page
value more than
291.
50 crore.
I'm sorry.
292. 63.
Yes, that doesn't apply to me. That's
Ah.
50.
Ah.
63 applies to me. I is this clause having advertised.
Correct.
Now, kindly come to 63.1. All disputes and differences of any kind whatsoever arising out of or in connection with the contract, whether during the progress of work or after its completion, and whether before or after the determination of the contract, shall be referred by the contractor to the GM, and the GM shall within 120 days after receipt of the contractor's representation make and notify decisions on all matters referred to by the contractor in writing, provided, now this is important, that matters for which provision has been made in clauses such and such. Now this list, my lord, includes 61 to 62(1) of the SCC stated as accepted matter. Shall be deemed as accepted matter, matters not arbitrable. Now, my lord, please see 63, 61.2 and 62.1. My lord, page 288. 61 is right of railway to determine the contract. And 61 is payment on determination of contract. And 62.1 is determination owing to default of contractor. So, my lord, 62.1, which is accepted, is the clause for termination for my contractual breach. And 61.2 is effective thereafter. So, no question arising out of determination of contract can go to arbitration. My lord, kindly see this. This is unfortunately a closed chapter today. 18, no? My lord, please see paragraph 3. And then, my lord, 248, my lord, at page 249, clause 63 is, my lord, quoted. And then,
49.
yes, my lord. 249, my lord. It's right at the top, accepted matter. Please see, my lord, 61 to 62, 1. Accepted. And then, my lord, please see para 18 and 19. Accepted matter, non-arbitrable dispute.
249, which?
Yes,
240.
my lord. 249, 9, my lord, is the clause 63
249.
of the judgment, my lord. I'm sorry, my lord.
Judgment. Para.
Para 3,
Ah.
my lord, on the second page, at page 249, is clause 63, which is pari materia, my lord, same. And then, my lord, paragraph 18 and 19, non-arbitrable.
Yes. Yes.
My lord, in fact, one of my large claims, my lord, rejected on the second day by Justice Bhaskar Bhattacharya on this ground. So having suffered, I know it's not possible. Otherwise, we would have filed section 9. Now, my lord, if I come back to the facts, my lord, what is diabolical is this. Kindly see, my lord, 1st July 26 at page 413. There are 3 notices. This is the 7-day notice.
Correct.
This notice says, we have asked you for bar chart. Paragraph 1. In spite of repeated instructions, you have failed to start work or show adequate progress. On 20th June, you have submitted bar chart over mail. June, you have submitted bar chart by email. The fact that on 9th June, submitted for WhatsApp and they gave us comments, they asked us to align it. Then paragraph, your attention is signal compliance report by 29. Compliance report is not accepted. Call letter long SMT items to be placed immediately. Now that's done. And I'm giving you 7 days notice. This work, paragraph.
Yes.
Now, things you will be ignoring that I was only supposed to do survey, which I've already done. Submitted drawing also for 1 out of 15 segment. Number 2, I have also placed for the entire cables. Number 3, I have placed RFQ for that main machine. You ignore that. Now, after you give this, then, my lord, next page, 6th of July is my response. Lord, we have prepared a short list of 6 dates.
No, but kindly come to the page 413. 7-day notice was given to you. What is
Yes.
your reply?
Reply is, my lord, 6 July.
414. Yes.
As per your reference letter such and such, we are submitting a plan in Excel format and submitted request for, they asked us to put in RDSO, request for RDSO inspection call letter, dated 1st July, 2nd July. We will be submitted request for call letter for MSDAC, that's much later. But what they wanted, my lord, that SMT, I've submitted on 1st July.
Yes.
Now, my lord, this is the bar chart which we were showing your lordship. There is no comment on this bar chart. They don't say it's not appropriate. And then, my lord, see 6. This is the RDSO, my lord. Request call for inspection. As they wanted, I do that. 6. Because I have already, my lord, placed RFQ and everything. Now, my lord, see the next document. 9th July, page 426. My lord, till now, whatever has happened, they ignore. And what do they say? 7 days notice was given to you. You have taken no action. This is premeditated. They want to give it to somebody else. You have taken no action to commence work. Reply is not accepted. What should be commenced immediately? My lord, I am working. You are given 48 hours notice.
Yes.
Now, my lord, please see page 427. My reply to this. Detailed. Number 1. At 427, I am giving a first response. Invocation is premature, not supported by contract. Why, my lord? We say then our earlier, number 2, our earlier reply has not been considered on merits. Number 3, I have done mobilization and commencement activities are in progress. Number 4, procurement of MSDSC. MSDSC is that machine that comes last. I have already done, my lord, steps for that. Those RFQs were placed. Then execution of signal requires coordination. You've not done this. Then proposed execution program in line with the discussion. The page 429. Civil execution agency is being mobilized. Determination of the contract would not serve the interest of the project. Our commitment, we'll do it within 24 months. Now, my lord, one request to your lordship, my lord, please consider. I have 24 months. I have done so much. There are no milestones. There is no breakup. Now, what permits you to terminate? Anticipatory breach of contract. That you're sleeping, you've done nothing. You cannot finish in 24 months. I can terminate. But this is not the case. It's only 2 months and I've done so much.
Okay. Yes.
Now, my lord, 431. Just, my lord, see 431. Not a single thing commenced. I considered in the termination. Not one sentence. And 432, my lord. Second last sentence at 432. We will, first they say you have not started work. 432 last sentence they say we'll put in somebody else for executing the balance work. This is totally malafide. Totally malafide.
Yes.
Lord, may I just sum up in 5 sentences? Just a summary. My lord, in the first 3 months, I am required to do survey of 15 segments. I have done survey of 8 segments and given final drawings for 1. No reference to this by them, though they are informed. Number 2, for the MSDAC equipment, which I need after 7 months, I have placed RFQ and I have purchased entire cables for 44 kilometers. No reference to any of this.
Yes.
Number 3, I was to submit a bar chart. They give me 4 letters, give it. Ignoring, I have given it by WhatsApp. You tell me that you have given some plan to railway board. I integrate that also.
Yes.
Then I submit it formally. You say put it in Excel. I give it in Excel, but you don't consider. Number 4, and most important, this is not, my lord, a milestone contract. This is a 24-month contract. So you can't fault me. Until now, I am with my bar chart. I am proceeding according to the bar chart. You have never criticized the bar chart. In fact, you wanted to improve it. I have done that. And lastly, in none of the notices, my lord, 48 or 7 days or 48 hours or termination, there is any reference to the facts of the case or my earlier responses showing that I have done the work substantially. And my lord, termination, my lord, is totally malafide. I've said so in the petition. They want to put in somebody else. And please think of a hapless contractor's position.
Yes.
I've invested so much, I've bought so much. What will I do?
Straightaway, my lord, your lordship, my lord, can you take, my lord, GCC first? That is, it starts at page 288.
28.
288.
Yes.
Blood 60, page 288, plus 62.1, determination of contract owing to default of contractors.
Yes.
Now, my lord, if your lordship, my lord, state next page 289,
Yes.
your lordship would find, my lord, there are 2 clauses, that is clause 12 and clause 13. Clause 12 says, fail to take to employ competent or additional staff and labor as required under clause 26 of these conditions. Next, clause 13 shall fail to afford the engineer or engineer's representative proper facilities for inspection, the work or any part thereof as required under clause 28 of these conditions.
Yes.
Now, I am referring to clause 26 and clause 28. Can you transfer page 252?
Two 52.
252.
Yes.
Now, you will also find clause 26.
Yes.
It says 26, the provisions for of efficient and competent staff at work site by the contractor. The contractor shall place and keep on the works of all efficient and competent staff to give the necessary directions to his workmen and to see that they execute their work in sound and proper manner. And they also employ only such supervisor, workman, and laborer in or about the proper manner and shall comply such supervisor, workman, and laborer in or about the execution of these works as are careful and skilled in the various trades. Number 26.3. In the event the engineer being of the opinion that the contractor is not complying on the works and sufficient number of staff and workmen necessary for proper completion of the works within the time prescribed, the contractor shall forthwith, on receiving the intimation to this effect, deploy the additional number of staff labor as specified by the engineer within 7 days of being so required, and failure on the part of the contractor to comply with such instructions will entitle the railway to rescind the contract under clause 62 of this contract. Now, let us see clause 62 once. Your Lordship, kindly clause 62, I have kindly text page 289.
Yes.
Well, after Roman 16, page 289, after Roman 16, may I just then in any of the said clause, the engineer on behalf of the railway may serve the contractor with a notice, perform at annexure such and such, in writing to the effect, and if the contractor does not within 7 days after the delivery to him such notice, to make the good of his default, in so far as the same time is capable of being good and carry on the works and complying with such directions as aforesaid, the entire satisfaction of the engineer. 289. Engineer. And the railway shall be entitled after giving 48 hours of notice performance as and such in writing under the hand of the engineer to rescind the contract as a whole or in part as may be specified in the notice. And after the expiry of 48 hours notice, a formal termination as the case may be should be issued. So, Milord, this is a purely commercial matter. What I have done, Milord, absolutely in terms of the contract. Now, Milord, kindly text, Milord. I just refer, Milord, a few pages, Milord, regarding this. Now, Milord, so far as this SOCA is concerned, Milord, kindly take first what I have, page 41. Kindly text page 413.
Yes. But Mr. Tiwari,
Yes.
you have placed the clauses with regard to the non-deployment of the efficient officers or the employee at the site. Correct. But you are noticing, yes, come to the 413. That's not the ground.
No, Milord, I have given as many as, Milord, kindly text, Milord, 413 first.
But after your notice, there are a continuation with the correspondence, and your authority has received the bar chart, whether the bar chart has rejected.
No, bar, it was informed to them, the bar chart is not informed.
Where is that?
Well, that information I don't have, Milord.
So,
it is not. Milord,
if
kindly see, Milord, one.
show that your authority after 26/6/2026 informed the petitioner the bar chart is not in accordance with law, then that could be. But there are communication all of a sudden here. You should
No, kindly see, Milord, so far
to the 413.
Yes. That is on 1st of July 2026.
Correct.
But my Mr. Chaudhary has placed it, I am not placing it. Now, Milord, next, Milord, a series of SOCAs is given. Milord, kindly have a look, Milord, last, Milord, this is, Milord, page 426.
Yes, 426, 48 hours notice.
48 hour notice.
Correct. Correct.
Now, kindly come page 30, 430.
430, yes.
Now, Milord, they have clause 64. Now, clause 64 of the GCC. Now, Milord, when the efficacious alternative remedy is available, Milord, your Lordship would go into all these things. Milord, kindly consider, Milord, let us see, Milord, 64 once.
If what?
64, clause 64, my lord, page 297.
297.
Yes.
Yes. Which one? 64,
Yes, my lord.
297, which clause?
Yes. But kind of page 293.
293, yes, on that.
Yes.
293, demand of
Yes.
arbitration.
Now, my lord, prior to that, my lord, major place, my lord, 291 once. My lord, I'm sorry, my lord, I'm traveling a lot, my lord. Can you see, my lord, page 291?
Yes.
Matters finally determined by railway. It says, my lord, all disputes and difference of any kind, whatsoever arising out of or in connection with the contract, whether during the progress of the work or after its completions, or whether before or after the termination of the contract, shall be referred to the contractor to the GM. And the GM shall, within 120 days after the receipt of the contractor's representation, make and notify the decisions of all the matters referred to by the contractor in writing, the matters for which the provisions has been made in clause 7J, such and such, 61 also cover, 61.2 and 62.1 of the such and such, or in any clause stated as accepted items of the special conditions of contract shall be deemed to be accepted items, matters not arbitrable, and the decision of the railway authority thereon shall be final and binding on the contractors, provided the further accepted items shall be referred or excluded from the purview of dispute adjudication board and arbitrations. So, my lord, he has the right to approach, my lord, in view of
No, kindly come to 62.1.
62.1.
Yeah, 62.1.
Yes.
62.1, what says? 62.1.
62.1 says, my lord, determination of contract owing to default of contractors. Now, my lord, it says, if
No, as per your case, it has been failed to 12 and 13.
12, 13 and other clauses, my lord.
So 12 and 13.
12,
If
13
it
and
is
other
coming under the 62.1,
Yes.
62.1, so it is it cannot be. Arbitration cannot be. As per
It
this,
is not arbitration, my lord. It has go to the GM. But this is a not a, they will have a contact. Can you see? All dispute and differences of any kind whatsoever arising out of or in connection with the contract, whether during the progress of the work or after the completion, whether before or after the termination of the contract,
correct,
shall be referred by the contractor to the GM, and the GM shall,
within
within 120 days after the receipt of contractor's representation, make and notify the decisions on all matters referred to by the contractor in writing, provided the matters for which the provisions has been made under clause such and such,
provided. Contractors provided the matter which provisions has been made in clause so and so.
Yes.
Provided means 62.1.
Yes.
So
Number 62.1, my lord, it comes in the my lord, accepted matters. And if it is
stated to accepted matter.
then my lord, GM has the authority. But
That's why the 63.1 is with regard to the authority of the GM.
yes,
Authority, if any dispute, it has to be placed before the GM.
Yes.
GM will decide within 120 days,
yes,
provided that these matters will not come under this clause, which are to be accepted matter.
That is 64.1.
Which is accepted matter, then how the GM can 62.1 and 62, your case is under 62.1.
yes.
Then how the GM can decide?
Now, my lord, so far as my lord 63.1 is concerned, my lord, 63.1 is says, my lord, GM will decide, my lord,
Correct.
if the representation is made.
No, GM will
Provided.
decide within 20, provided that the matters for which provisions has been made in clause, provided that. Yes.
Provided that the matters for which provision has been made in clauses 7J, 8, such and such, 61, 2, 62, 1,
Correct.
63, 4 of
Standard
the standard general conditions of contract or any clause
as accepted matter.
accepted matters.
With my learned friend's permission, my lord, if I only show your lordship 64, which is at page
Demand of
293. There you cannot make a demand for arbitration for accepted.
Yes, I am also admitting that there is not, but except so far as not accepted matters, arbitration cannot be made. That is 64 is clear. But these are not coming into the accepted matters. But these are in my reference submission, these are accepted matters, and if accepted matters are there, the GM has authority, my lord. So far as accepted matters, no arbitration is there.
Okay.
Now, kindly look at another clause is 60. That is not admittedly, the tender is less than 50.
Yes.
So, my lord, this second clause, my lord, dispute adjudication board, my lord, has no jurisdiction. Now, my lord, so far as my lord, 63.2.14, my lord, page 293.
63.2.14.
63.2.14. Yes, page 293.
Yes.
It says it is a term of this contract that the parties shall not approach the court of law for settlement of the such dispute and differences unless an attempt has been made by the parties to settle such disputes and differences through the DAB and arbitral agreement, arbitral tribunal. Well, so far as this is concerned, I am not issue. But the fact is, Milord, when they are also saying so, Milord, kindly have a look, Milord, they are reply to the so-called notice once. They are reply to the so-called notice, Milord, your lordship will not get it. Kindly see.
Yes.
It is not at page 427.
Yes. Yes.
427. Now, my lord, I am not placing the entire thing. Your lordship will not kindly turn, my lord, page 429. Clause 10, point number 10, reservation of rights.
Yes.
It says this reply is submitted strictly without prejudice to all rights and remedies available to the such and such under the contract and applicable law. Next page, my lord, page 430. Nothing contained herein shall be construed as a waiver of any contractual or legal right available to the contractor. Contractor expressly reserve all the right available under the contract, including but not limited to the provisions relating to the dispute resolutions and arbitration under clause 64 of the standard general conditions of contract. In any event, the action is taken contrary to the provisions of the contract. So, Milord, he has submitted more or less, Milord, to the jurisdiction of the Milord, alternative dispute resolutions. And not only that, Milord, kindly have a look, Milord, once again, Milord, the termination letter. Kindly see, Milord, the termination letter once.
Yes.
Milord, it is, Milord, at page 431. 431. The Milord, you will also find, Milord, in the termination, it is dated, Milord, 14th of July 2026.
Yes.
The Milord, you will also can see, Milord, reference. How many letters were given to them? Well, as many as, Milord, 16 letters. 16 letters were given. There was a correspondence, Milord, they were asked to submit documents, they did not do that. Now, Milord, sign this, then, Milord, can you may I place it? After the issuance of a letter of acceptance for the work on 25/4/2026, the multiple communications were made to you regarding the submission of the bar chart and the start execution of work by reference number such and such and such. You have annexed, you had submitted the annexure 2, duly mentioning the dates for placement of purchase, order of cables, MS DSC, and other signaling gear. However, these timelines were not followed. The timeline mentioned in the bar chart submitted by you on 29/6/2026 is also not being followed. So, I am admitting this. They have submitted the bar chart and it was not followed also. Since no physical work has been started by you, even after passing more than 2.5 months, the issue of LOA at 7 days notice was served on you to start the work immediately. However, again timelines were given by such and such, which is not accepted to the railways. Target for the year 2026-27, this work is already communicated to the railway board, and the same has also been intimated to you by letter reference number 7. 48 hours notice was given to you under this office, letter number such and such, by reference number 15, but you have not taken no action to commence the work or show adequate progress of the work. Since the period of 48 hours has already been expired, above contract stands rescinded in terms of clause 62 of the standard general conditions of contract, and balance work under the contract will be carried out indefinitely without your participations. Your participations as well as participations of every member or partner in any manner as an individual or partnership firm such and such is hereby debarred from participating in the tender and executing the balance work, and your security deposit shall be forfeited and performance guarantee shall also be encashed. Now, can you see, I just refer 2 pages. What the work order was issued on 25/4/2026. Now, this is a project, public utility service will be provided. Now, this is a project, in basically it is the replacement of auto signaling by using multi-section digital axle counter. But this is from Bali to Bandel. Well, this is a public project and safety security is the main function. Now, this letter of acceptance was issued on 25/4/2026. Now, from 25/4/2026, today we are in the middle of July. What progress he has done? Nothing. Number one, he is saying that he has purchased the cable. Now, he is also having another project at Asansol. He purchased the project and cable and all these things. Now he is trying to do saying that these purchase cables and all these things will not. These projects also delayed. So far as Asansol project is concerned, that has also been delayed. That is my instruction. I am telling on instruction. Now, kindly have a look. Just few pages. I will show to your lordship. Can you take page 8 of the repetition, paragraph 13. Page 8, 2 paragraphs. I will just show to your lordship, Lord.
Yes.
Now, paragraph 13 says, the petitioner has completed a cable route survey for 7 locations out of 15 locations. The vendor finalization process has been undertaken and almost completed for 3 civil vendors and 3 signals and telecommunications vendors and 1 original equipment manufacturing vendor. The petitioners have also requested the research, design and standard organizations for conducting the inspection for signaling and squared cable for their approval. Call letters have received, acknowledged and replied by the respondent railways. Now, this is a project concerning say 15 locations. Now, 2.5 months gone, they just inspected only 7 locations. Another 8, they could not even touch it. Now, kindly consider this.
So that's why the bar, unless and until the bar chart is not.
It is stated, in my termination letter, I have categorized stated. They have submitted on 29.
Chart is not approved. The timeline. How you can fix the timeline?
Bar chart. So far as bar chart is concerned, kindly state away. Again, come to page 200, 400. 431.
401. 409.
No, 431.
431.
431, paragraph, I have said, however, these timelines were not followed. The timelines mentioned in the bar chart submitted by you on 29/06/2026 is also not being followed. Now, this is a contractual matter. Your lordship will kindly consider these are the absolutely contractual matters. Now, I have given the contract on certain terms and conditions. Now, they have also agreed to the terms and conditions of the this tender documents. After accepting these, all the tender documents they put their signatures. Now, they fail to act in terms of the tender document. Now, this is a public project. Now, not only that, there is a provisions they can approach to the GM. But it is not habitable, but it has gone to the GM. It has to go to the GM. They have admitted that. So, in this circumstances, whether your lordship would be interfering in this thing, this.
The 4 sentences. 391. His first allegation. You have purchased for some other project. Please see 391. Please see the purchase order.
Yes.
Left, top is a box. Right at the bottom of the box, project code, project name. Because everything has to be approved by RDSO. So you have to say all this to the purchaser.
Yes.
And this is LLH BDC section. Now, see the termination notice at 431.
Yes.
First paragraph, LLH BDC section. Axle counter MSDC at LLH BDC section. It's for this contract.
Okay.
So my learned friend says this, that's not correct. Number 2, bar chart never rejected. Bar chart will not, and if your lordship sees the bar chart, he says, why haven't you surveyed? Out of 15 sections, you've only done 7. Bar chart says, I've got 11 months to do, the full thing. So, this is unbelievable. Now, just 2 more points out of the 4 which I mentioned. He's shown a letter saying that go to my engineer. Client wrote that I'll go to arbitration if you're doing this. I'll happily go if he says there's an arbitration agreement. Let him say There's an
So he's
arbitration
telling,
agreement.
it is not arbitration. You have to
Then
go
I
to
can't go and appear before the engineer and ask for these
you have to
orders.
go to the GEM because you have accepted the contract. You have accepted the contract. Kindly come to the page 63 in the paragraph 62.
Para 62 of the writ, my lord.
Yeah, 63.1, page 291.
Oh, of the contract. I'm sorry, my lord. I'll
Contract.
just come to that.
291.
Yes, my lord. This is totally accepted matter. I can't go to arbitration.
No, kindly see. You have to go by the not arbitration. That's the GM.
Yes.
You have to go to the GM, and the GM will decide within 120 days after receipt of the contract representation.
Right.
That's why it is coming under. It is not the arbitration. It is to the GM to decide within 120 days. And you accepted this contract.
Yes.
Then
But that's not an equally effic. So, my lord, I can't go to arbitration. I can't file a section 9. I can't even challenge the termination before a writ court. I'll have to go to the GM.
Yeah,
Yeah, that's not, my lord.
that you accepted.
So,
Can
Milord-
you see all dispute and
So-
difference of any kind whatsoever?
Yes, correct. Now, my lord, GM, request to the GM to decide cannot, my lord, be an alternative efficacious remedy.
Once you accepted that, you
So,
that
Milord,
yeah,
may I
if there is a
humbly-
dispute, you have to go to the GM. Then now after the acceptance and you have taken the LOA, then now you cannot challenge that. That
Very well, my lord. Let me go to the GM. Let him decide, my lord, within a
120
time.
days is there.
Then let him not take any further
That's
step.
that is your if they will take that is separate cause of action. How the
But
court?
they are saying that kindly.
Yes, you gone through. You
Termination notice.
will not be allowed to participate. That's when they will go.
Everything gone. And this
Correct.
is Texmaco, my lord, one of India's largest railway rake manufacturers. And my lord, so my lord, today my situation is, as per my learned friend's interpretation of my rights, I can't file section 9. I can't go to writ court. I'll have to go to GM. GM will decide in 120 days. I can challenge that decision later.
Correct.
But for the present, I can't do that.
For the present, if that's why if
And I
cause of
can't
action-
give interim order also.
if present in any cause of action, you have a right. But at present, how the court can, without you invoking the provision 63(1), how
Yes.
this court can, and how this court can pass any interim order in this writ application, not to publish any tender or whatever. It is still the decision of the GM. How this at this stage?
Milord, so my
I can
rights.
just help Mr. Chaudhary,
Yes.
Milord, only one thing. Instead of 120 days, Milord, your loss will direct the GM Milord to decide it Milord, within 30 days.
And no action till
No,
then.
no, that can I can,
So
I
then
can.
what is the my bank guarantees will go, my contract will go, I will be blacklisted. One of India's largest railway rake manufacturers will be blacklisted by railways.
Only this tender.
No, but
It is not
yes,
only
the
for the
bank
tender.
guarantee, and this tender will go.
That's it. That will GM
And
decide. GM
so-
if will decide against you, then you have a chance. It is not the GM is the final authority.
But then till GM decides, till that time, they will take away everything.
You request the GM. Either you decide or to direct the authority not to proceed further any further tender. You request. If it is not, then you have a right to further course of action.
Milord,
How?
Milord, then permit me, Milord, to go and request. Milord, I want a chance, Milord, in the facts of this case. Milord, permit me to go to the GM.
Correct.
I will file today.
Correct.
And Milord, let him decide
Hmm.
within 3 days. And I will not,
Serious, you have to see, he has to take the report, you have to submit the report. That's why Mr. Tiwari has
But give
given
me-
his
give me
specific
some-
30 days.
but
See, Mr. Chaudhary, tender also, you know that 21 days is required for the publishing of tender finalizing 30 days.
bank guarantee.
So GM decided all the things will be the GM 431 before the GM. If the GM came to know held that this is order is wrong, so automatically the bank guarantee will be revoked. What you are challenging before the GM?
Milord, I am challenging the termination before the GM.
Then
I'll go, Milord. I'll happily go.
yeah,
Milord, kindly just protect me. I'll happily go.
how?
But
this
at least, Milord, give me liberty to pray for an interim protection from the GM?
Always there.
And Milord, give me that liberty. Milord, otherwise he'll say he won't decide. Let him decide interim protection within 2 days. That much give me.
That you have every once they have given the right to authority to the GM has to decide everything. It is not the GM can
Kindly only
decide.
say that.
Yes, I will decide record that. Upload कर the order.
And also, Milord, please record my undertaking to file an application before the GM today.
It
No,
is
I am undertaking.
Oh, I will record your.
And another undertaking will not
So
super.
you want the court can go to on merit it has to be given or only on because on
Only this, Milord.
so
I try to be fair to the court.
now if it's in a merit then I will go to
No, no. Why will I? Your Lordship always indulges us. I will file today. This writ petition, Milord, Mr. Ghosh will ingeniously change the heading.
Then let the retribution be treated as representation. Then the problem will be solved.
writ petition cannot be given to the authority.
You can't deprive Mr. Ghosh of his job.
No, Mr. Ghosh will go and cut paste.
Immediately. Only change heading, change class title to the
Petitioner
GM.
has filed the present writ application challenging the order dated. Thank you. Order dated 14th July 2026, wherein the respondent authorities have terminated the contact of the petitioner and also recorded that and also debarred the petitioner for participation in the tender for executing the balance work, and the security deposit of the petitioner shall be forfeited. Security deposit as well as the performance guarantee shall be forfeited and encashed. Forfeited and encashed. ठीक है? नहीं एक काम कर security deposit will be forfeited and performance guarantee shall be encashed. Landed Council appearing for the railway authorities raised a preliminary objection with regard to the maintainability of the present application. Council for the respondent submitted that as per clause 63.1 of the tender talk conditions, the petitioner has to make a representation to the GM, and GM shall within 120 days after the receipt of the contract's representation shall take a decision and will communicate the same to the petitioner. Full stop. This as the respondents have raised the point of maintainability, according the court has not gone into the merit of the matter. Clause 63.1 reads as follows. Page number 291, 63.1. 292, first paragraph. Full stop. As per the said clause, clause 62 and full the contract of the petitioner is determined owing to default of the contract as stipulated in clause 62.1 of the tender corner of the contract of the general clause of contract. 63 clause 62 within bracket 1 clause 62 within bracket 1 is the accepted matter, and as such the petitioner cannot invoke the arbitration. The only remedy before the only remedy to the petitioner to make a request to the general manager, and the general manager shall decide the matter. Then counsel for the petitioner submit that if this court will allow the petitioner to make representation to the general manager in terms of clause 63.1, comma, the petitioner immediately make an appropriate representation to the GM, and he prays for a direction upon the GM. Instead of 120 days, the GM shall decide the matter as early as possible. Heard the learned counsel for the respective parties, peruse the materials on record. This court find that the contract has been terminated by the respondent authority by taking into the consideration of 62.1, and 62.1 is the accepted matter for invoking the arbitration clause. As such, the petition is required to make a representation to the general manager, and the general manager shall decide the same in terms of clause 63.1. In view of the above, the petition is given liberty to make appropriate representation along with the documents as relied by the petitioner to the GM within a week from date. If any representation is made by the petitioner, instead of 120 days, the GM shall decide as early as possible, preferably within a period of 4 weeks from the date of receipt.
Not including for interim relief.
It is also made clear that if the petitioner make any request to the GM for any interim relief, pending decision by the GM, the GM shall decide the request of the petitioner on merit for grant of interim relief. WPA.
And Miller, if you're
It is also made clear that this court has not gone into the merit of the matter. It is the GM shall decide its own merit and decide all the question, if any, raised by the petitioner. Grateful without being influenced if any observation made in the present.
But I have a
Your lordship has given any timeline?
4 weeks. Instead of 120 days, 4 weeks
that I
from the
have
date of receipt of the report.
4 weeks to consider and pass the interim order.
No. 4 weeks.
Completely disposed of.
Mr. Tiwari told that, and in the meantime, he made any request to the interim.
But I will do it today. But I have a feeling we may come back in the same case. Grateful, Miller.
I hope should not. Yes.
Grateful, Miller.
For the writ petitioner in this matter, the petitioner, my lord, is an operator of a railway contract, and petitioner has participated in an e-auction in 2024. The tenure of the contract is for a period of 2 years. Now, my lord, the petitioner contract is overall governed by the Railway Board Freight Marketing Circular, which have a statutory force, which derives its power from Section 2 and 3 of the Indian Railway Board Act. Now, my lord, at the time of initiation of the contract, my lord, I was told that there will be no provision for extension, even if my performance is satisfactory. But thereafter, my lord, an amendment was effected where an exception has been carved out, stating that a contract which has a tenure of 3 years, I have a tenure of 2 years. The contract which has a tenure of 3 years, there, my lord, the extension will be provided. But in my case, even if I exceed, or even if there is no allegation of any breach or of any sort of my performance is satisfactory, there is no provision of, my lord, of granting of
My lord, matter is to be hard under the
my lord,
Group 7 matter. Is
no, this is a Group 9 matter. This is, I have challenged the virus of the circular.
kindly see the High Court
What you
affidavit.
challenge?
I have challenged the virus of the circular.
Circular of?
Circular of the railway board. My lord, kindly see.
Where is the circular?
The circular is at, my lord, that is at page 125. A specific provision of the circular has been challenged, my lord, and its constitutional validity. If your lordship kindly sees page 127 for once. I have challenged the constitutional validity on the ground that it contravenes Article 14, 19(1)(g), 21.
Which clause? Which clause?
Which clause is in the paragraph 9.1.1. That is at the second heading.
Extension of long-term
Yes,
parcel leasing contract.
yes, my lord,
of
may I
this
just
may
from
be
the middle.
permitted subject to the following conditions. Yes.
Yes, new para inserted below para 9.1 exclusively for long-term leasing exclusively for long-term parcel leasing contract of 3 years as under. Extension of long-term parcel leasing contract of 3 years may be permitted subject to the following conditions.
Yes.
Lord, mine is of 2 years.
Hmm.
Based on the satisfactory performance of the leaseholder without any penalty imposed for overloading or without violation of any provision of the contract, PCCM
of the zonal railway may grant extension of the contract on the basis of recommendation of the division with proper justification and with concurrence of the associate finance. However, maximum 2 years extension can be granted each for 1 year. My lord, kindly take the first paragraph, paragraph 9.1, which was amended. Paragraph 9.1, which was applicable in respect of all tenures of irrespective of 2 years, 3 years, says that normally extension of the contracts awarded through e-auction shall not be permitted when I was entered the contract. However, in case of expiry of the contract before the finalization of new contract for any asset, due to administrative delays, temporary extensions can be granted with the approval of DRM consent of PACHOD without finance concurrence. The total duration of such extension shall not exceed 3 months, and effort should be made to ensure that the next contract is finalized before the expiry of such extensions. Rent, lease fees, and other applicable charges of these assets shall be paid by the contractor for the extended period on pro rata basis. Now, my lord, when I entered the contract, there was no provisions for extension. Now, in the middle of the my contractual tenure, my lord, an exception has been carved out in favor of 3 years. Now, my lord, the Railway Board Act, Indian Railway Act clearly says that if similarly,
what is the
My lord, my submission is this, according to the, my lord, the group swim determination. My lord, the 1A is railway, 2, my lord, 1 is booking dispute with regard to the rates and, my lord, kindly see that.
there is no provision, my lord, I have checked it. I have challenged the virus of this circular.
My lord, kindly see 7A,
yes,
that is railway. My
7,
lord, 1 booking and dispute with the regards to.
7,
rates.
7A.
Yes, my lord, group 7. That is matter relating to the transport and communication may be divided under the following subheads.
Correct.
So matter is related to the transport and communication, that there should be.
Yes.
1 railway,
Hmm.
booking and dispute with regard to the rates and tariffs.
Correct.
2,
Hmm.
allotment of wagons, rates and cancellation thereof.
Hmm.
My lord, this matter is under 2, my lord.
Hmm.
A2.
Hmm.
My lord, because my lord, that is ultimately that is related to the allotment of rates. My lord, what they want, my lord, his contract period will be ended for a certain.
What is the contract for?
Contract period is, my lord, that will be ended on tomorrow, my lord.
What is the contract for?
Contract for leasing of a parcel van.
Ah.
So, my lord, leasing of a parcel van, that means that the allotment of wagon rakes. Rakes and parcel van are same thing, my lord.
My lord, I am not asking for any allotment.
And my lord, kindly see what
Challenge
is
the
the
rights.
matter. My lord, kindly see the.
Where is the tender?
Tender portion is not there under group 7.
That's why where is the tender?
My lord, what is the tender? Tender is also for the allotment of rakes also.
Sir, in that case, this could.
My lord,
I will release all the matter.
Yes.
This
Yes.
tender may
My lord, in earlier.
go to the BSNL code. This tender goes to the education. Go
Yes.
to the education code. This tender go to the.
No. That is not submission. That is not my submission. My
lord,
earlier questions. That was heard by the group 7.
Kindly see section
Kindly
70.
recorded that only one. This is my
Fine,
submission.
Kindly see section 70.
Extension need contract.
70 is clear that my lord has found.
Yes.
Section 70. A railway administration shall not make or give any undue or unreasonable preference or advantage to or in favor of any particular person or any particular description of traffic in the carriage of goods. Now, my lord, we are the leaseholders of 2 years contract, 3 years contract are also the leaseholders. They are all operating under one leasing framework. They are all under same commercial framework. There is no difference in between their mode of doing business, my mode of doing business. I've elaborately, categorically stated in my paragraph 14. Both of us have to participate in the e-auction. Both of have to have the requisite financial criteria to make ourselves.
Okay, let them file affidavit.
Let them file affidavit.
Yes.
Let them file affidavit, and also, my lord, I will be relying upon several Supreme Court judgments
Because you are challenging the virus.
Because
You are challenging the
Yes, I
virus.
have
It has to be decided only after.
yes, reasonable classification, my lord, has 2 tenets: intelligible differentia and the rational
Correct,
nexus.
correct, I
That does
appreciate.
not meet.
Let they come with an affidavit.
The only thing, my lord,
What circumstances they have done.
my lord, only one thing I am prejudiced to this extent is this. My lord, I have made one representation and they have rejected it. But the rejection is not on the basis of performance standard. Rejection is on only on the basis of a tenure, and tenure cannot supersede the.
Sir, very first moment I ask what is your impugn order. You are telling there is no impugn order. You are challenging the virus.
No,
So
I
you
have
are-
challenged its legality also along with the virus.
What
Because
legality?
legality of the and propriety of this impugned speaking order, which is absolutely contrary to the constitutional mandate.
What is a speaking order?
The speaking order, my lord, I
Where
have.
is the page?
Where is the page at 143? Well, this needs to be stayed because of the reason that they have not at all considered my performance, which is the only criteria. They have considered something else.
Yes.
If you should kindly see from second last paragraph, second last paragraph of the impugned speaking order.
When this amendment was affected?
Amendment was affected on 24th of March during the
24th
validity
of
of my
March?
tenure.
24th of March?
March 2026.
Yes. And when your contract was awarded?
My contract was awarded in the year 2024 and is going to end by tomorrow. So during the validity of my agreement, my lord, this amendment has been brought. They want to exclude me. They do not want to grant me any extension because of my tenure, though my performance is satisfactory and there has been no complaint and no whisper about my performance in the impugned
So
speaking order.
what is your right to ask for the extension? If
My only right,
authority to
my
decide.
only right, my lord, is for a fair, equal, and non-discriminatory consideration.
That will be decided whether this is
Okay, my lord, let
discriminatory or
it be
not.
decided. Let it be decided.
It is
A short
decided.
period-
That
short time may be
that
given.
will be decided whether discriminatory or
Yes, my lord. I
by
give-
giving the extension to the 3 years and above, not
Great.
giving the extension but
Great.
2 years below the 2 years, whether there's a discriminatory power of the authority or not, that is to be decided on.
and also, my lord, the violation of the doctrine of level playing field, doctrine of
That is-
reasonable classification and fairness.
The petitioner has filed the present writ application challenging the amendment in the tender circular.
In the amendment, freight marketing circular 11 of 2022, which is at
The
page
Freight
120.
marketing circular number 7 of 2026 at para 9.1, by incorporating that the extension of long-term parcel leasing contract for 3 years may be permitted subject to the conditions, but the less than 2 year but the contract up to the 2 years cannot be considered for the extension. This court find that this writ petition is to be disposed of only after exchange of affidavit. Let affidavit and opposition be filed by
4 weeks, madam.
4 weeks will be too late.
3 weeks. Reply if any there to be filed within a week thereafter. Full stop. The ऊपर जाएगा affidavit of service kept in the record. Let the matter appear on 13th August under the heading adjourn motion.
Grateful. Very good. Great.
तो बुक दे दो उनको.
Get
I'm for the petitioner.
Yes.
I've come up before your lordship, my lord, challenging termination of a letter of acceptance and also issuance of eviction notice. But if I may briefly place the
Eviction
facts.
notice.
Yes, my lord.
Under
Eviction-
public premises.
No, my lord. Arbitrarily, eviction notice has been issued, my lord, and forcibly trying to be evicted, my lord. But if I may place the facts, my lord, in a nutshell, my lord. But the petitioner is running a petroleum outlet at a given destination under a lease. But the lease was for a period of 15 years. That expired, my lord. Upon expiry of a lease, my lord, a request for a tender was being floated in the nature of request for proposal. I became the highest bidder. Tender condition says that within a specified period of time, I am to put in my bank guarantee, and thereafter they will execute the agreement. Within time, my lord, I put in my bank guarantee. Thereafter, I write to them that the plot of land which you have offered is not in consonance with the description given in the tender condition. I write to them to go for joint inspection. Joint inspection is being carried out. They refuse to sign in the joint inspection report. At the same time, I have been continuously writing to them that I have complied by putting in my bank guarantee, you execute the agreement for lease so that I can continue and go ahead with the project work. But suddenly, without assigning any reason,
they issue a cancellation of the letter of acceptance. I give a reply to them that these are the defaults that have been committed by you please reconsider, madam. Without reconsideration with it, they issue a eviction notice, that is without any basis, under unknown provision of law. And what they thereafter do is they thereafter get in machineries to forcibly stop the petroleum outlet and evict us. At that juncture, my lord, I came up, my lord, before your lordship, there was an entry order, my lord. Today we are on affidavit, my lord. This is the pith and substance of the matter, my lord. My lord, the first document that, my lord, I wish to take your lordship to is a request for proposal.
Where is the cancellation of the eviction order?
Cancellation, my lord. My lord, that
Eviction
is the
order?
letter dated 3rd of June 2025, which is at page 169 of my writ petition.
One
169 of my writ petition.
eviction order.
No, not the cancellation of the letter of award.
169.
Yes, my lord.
169 is something else.
Ma'am, 1 second, my lord. Letter of cancellation. Well, 21st is a third. Page 170. I'm so sorry, ma'am. 174, my lord. But this is a letter dated 21st of August 2025, my lord. In this regard, my lord, the subject says development of wayside amenities such and such. Reference is letter of award, my lord. This has reference.
Which matter you are referring? Item number?
Item number 3, my lord.
WPA number?
7634.
Yes. 174 is not.
Well, 174 of the writ petition, my lord. But there was a supplementary affidavit and 2 oppositions filed by my learned friend, my lord. But it's in the volume 2, my lord. There were 2, it's been segregated in 2 volumes, my lord.
Yes, 174.
But page 174, my lord, this is a letter dated 21st of August 2028, my lord.
Yes.
Development, operations and maintenance of wayside amenities. But it indicates the letter of award such and such. Reference is letter of award dated such and such. Thereafter, my lord, they admit the fact that I put in the bank guarantee of Dankuni Palsit, leasehold rent such and such. Serial number 2, if your lordship sees, the details of the bank guarantee submitted by HPCL are as under 1 crore 29 lakhs and all. This is in this regard, it is to inform you that the LOA issued to HPCL is hereby withdrawn with immediate effect without any financial implication to both parties. Accordingly, HPCL may depute a representative to collect the performance bank guarantee and along with authority. No reason at all. No reason at all, my lord. I, my lord, immediately give a reply to it if your lordship comes to the next document, which is at page 175.
Withdrawn with immediate effect without any financial implication to both the parties. Both the parties means? Acha. Okay. HPCL may depute representative collect the performance bank guarantee. Yes. Then?
But I immediately give a reply to them, which is a letter dated 10th of September 2025. If I may place the letter, my lord, I have put it in detail, my lord. This has reference to the request for proposal dated 8th of January 2024 for WSA Govindapur, such and such, wherein HPCL was declared as the highest bidder, in furtherance to which letter of award dated such and such was issued in favor of HPCL. In pursuance of the LOA, HPCL deposited the performance bank guarantee for an amount rupees such and such on author, which was duly accepted by you. We are surprised to have received your letter dated 21/8/2025 withdrawing the LOA, which states withdrawal of the LOA with immediate effect. Please note your letter withdrawing of LOA is arbitrary and in violation of RFP terms inter alia section 2 of the instruction to bidders clause 7.2, 7.3 at page such and which I will place, my lord. But it has been also set out, my lord. 7.2, my lord, if your lordship takes care of, the bidder whose bid has been accepted will be notified for the award by the authority prior to expiration of the bid validity period by cable, telex, such and such, confirmed by a registered clause. 7.3 is important. The notification award will constitute the formation of contract subject only to furnishing of a performance bank guarantee in accordance with provisions of clause 8 and as per annexure 4. As per the above clause, furnishing of the performance bank guarantee pursuant to notification of the award constitutes to formation of contract. Therefore, there is no provision under RFP to withdraw the LOA after formation of the contract. While letters dated 18/4/24, 25/11/24, 11/12/24, 9/6/25, we have time and again requested you to fix a date to sign the formal agreement in compliance with clause section 2 instruction to bidders and clause 7.4 at page 23 of RFP and 0.5 of the LO. As such, you are requested to come forward to execute the lease agreement to comply with the terms of the RFP as well as the LO. But what they do thereafter, my lord, but thereafter, my lord, we again write a letter to them on 3rd of October. But which is at page 177.
Yes.
This is reference to a letter dated such and such, my lord. Well, I'll take your lordship to the relevant paragraph. Paragraph 3, if your lordship comes to, it appears to us, the third paragraph, that this decision has been taken in light of ongoing dispute with the concessionaire on handing over the wayside amenities and the same being in sub judice matter, as have been referred to in point 4 in your letter dated 3/6/2025, being reference number such and such addressed to HPC.
So this is a representation. Then what has happened?
Thereafter, my lord, if your lordship comes to page 179. Now, first, this is the eviction notice that they issue to us. Subject such and such, contract dated such and such, letter dated such and such. But this is in reference to your office letter dated 3/6/2025, wherein it was directed to revoke your operation and vacate WSA Govindapur such and such immediately, as no valid extensions were granted to you. Furthermore, you had requested this office to allow to continue its operation on the said WSA at Govindapur, while your letter dated 3/10/2025. Accordingly, the same was examined, sent to the competent authority. Now the competent authority has given the following direction: cancel the lease with immediate effect, give notice to vacate the area, cut off all access to WSA, no lease amount shall be further accepted. In view of the above, you are requested to follow the above direction, as no valid extension has been granted to you by competent authority dated 19 September 2023. It is directed again to revoke your operation and vacate the said wayside amenity with immediate effect. But one document which I will take you into.
No, this reference to the office letter 3rd June. What is the 3rd June?
The 3rd June, that is what I was trying to take your lordship now to. My 3rd June, my lord, the letter is at page
169.
my
169.
page 177 of my writ petition, my lord.
169, I think so. 177. 177 is 3rd October. 3rd June is the 169.
The 177 is third, I'm sorry, 169, my lord.
Yes, 160.
But if your lordship comes to the second paragraph, my lord, you have stated by letter dated 25/11/2024 that NHAI representative did not sign the MOM and drawing prepared during the joint survey on 16th October 2024, incorporating actual measurements. During the visit, our representatives informed your office that the existing service road, this is very important, the existing service road at the backside of the WSA will be discontinued and a new service road in front of the WSA area is under construction. The proposed WSA area of 5.76 includes the backside area which is required to be developed by your agency as per the WSA plan. Your representative did not agree to the proposed plan. As a result, the joint inspection report remains unsubmitted. It is pertinent to mention, but this is not part of relevant, but now paragraph 4 is the most relevant part. Apart from this, there is an ongoing dispute between NHAI and the concessionaire regarding handing over of the said wayside amenities, and it is in sub judice stage. But what?
Who is the concessionaire?
That's a third party. But now the actual story comes into picture. But I will take your lordship now to one document, my lord, which is also part of my writ petition, but I have disclosed a clearer picture, my lord, in my affidavit in reply, which is the picture of the site, my lord, which they had handed over, my lord, which will give a very clear picture to your lordship, my lord. If your lordship comes to my affidavit in reply page, affidavit in reply,
Yes.
Page 43. Page 43 of my affidavit in reply.
Yes.
But this is the entire plot of land which was given for tender. Plot A, plot B, and plot C. But I am already in possession in plot A by way of a earlier lease, and I am running a
Earlier with whom?
with respondent only, with the national
NHAI.
national highway authority,
Hmm.
and I am running the petrol pump till today from that. But in this particular tender,
Which A?
I am in possession of A. But in this tender, B and C was been added.
Hmm?
B and C plot number was been added. Now B and C plot number, they could not give possession to us because of that ongoing dispute with the third party. It was in possession with the concessionaire, which perhaps they have refused to hand over possession, and they have initiated a litigation which prevented them from handing over the possession to us. So when they could not give us the possession of this particular area, we wrote to them that there is discrepancy in the measurement system which we have provided. Let us go for a joint survey. They went for a joint survey, but they refused to sign the joint survey report. And in order to give a go by to the entire dispute ongoing, they straight away issue a termination.
If there is a dispute with regard to this, how the land will be given to you?
But how could it be tendered then? But I have fulfilled my obligation.
They might have been tendered, but it is not possible to give this property to you, or what the authority will do.
But I can't be evicted on that score because I have committed.
Where from you have been evicted?
But I am enjoying a protection from your lordship, my lord. They cancel it.
That this court has granted.
Yes, my lord. And they subsequently
possession of A. A is not the subject matter.
A is also included. Now ABC forms the tender. ABC forms.
How you are telling the A? You are in occupation of the A?
I'm still in occupation. I'm running a petroleum outlet from A.
Before that?
Before that, I'm in possession since 2008 by way of a registered lease.
With regard to the A?
With regard to A.
Then they have included the B and C.
2024, they float a tender making A, B, C a total complete.
A is also now in dispute.
A is not in dispute. I write to them that since I am in possession of A, you execute a lease in respect of A, as and when B and C.
Where is the earlier lease with regard to the A?
I have disclosed in a supplementary affidavit. Page 6 of my supplementary affidavit. It's a registered deed, there is no dispute with regard to that.
Registered deed with regard to how many years? Lease deed?
15 years,
Lease deed.
2008 for a period of 15 years, my lord. It expired in 2023, my lord. Thereafter, we continued to make payment of rent. In the interregnum, this tender was being floated, 24. And I became the L1 bidder, and accordingly, I continued to make payment. Okay. I have also tendered the rent up till the month of June 2026, my lord, to the respondent authorities.
Okay.
But the first document that, my lord, I intend to take your lordship to is the letter at page 46 of my affidavit in reply, my lord. A letter dated 18/4/2024, which I write to them after the issuance of the LOA.
Yes.
But this we write to the respondent authorities, my lord.
Where is our LOA?
LOA. But LOA is at (166) of the writ petition, my lord. But two documents, my lord, is very important, which I may place, my lord, the relevant clauses of the request for proposal and the LOA. But LOA is 13th of June, March 2024. But if I take your lordship to the first paragraph, this is to notify that the competent authority has accepted your proposal for the site NH19, Palseat such and such, area 5.76 hectare. Well, the total area which they provide under this standard is 5.76. Under subject annual lease of such and such plus GST applicable such and such. Therefore, you are declared as the highest bidder as per clause 6.2 of the RFP. You are requested to confirm your acceptance within 7 days from issue of letter of award. You are also requested to submit a development performance bank guarantee as per clause 8 of the RFP for an amount of rupees such and such.
Have you submitted?
That I submitted within time. I have disclosed also. Upon submission of the required performance guarantee, you are also required to sign the agreement within 10 days of submission of the performance guarantee as per RFP. There where the breach started on the part of the respondent. They
Yes.
could not execute within 10 days in view of the ongoing dispute going on with the third party, my lord. But the next document I take your lordship is at page 167, which is the submission of my document, my lord, of the bank guarantee,
Yes.
which is admitted fact, my lord. There is no dispute, my lord. Now I take your lordship directly to the relevant clauses of the RFP. Clause 7.4, my lord, which is at page 52 of the writ petition.
Yes.
Now 7.3, my lord, this notification of award will constitute the formation of the contract subject to furnishing of the performance guarantee in accordance with provisions of clause 8 as per annexure 4. The agreement will be signed by the authority and the selected bidder as per annexure 3. After performance security is furnished, the bidder shall sign the lease agreement within 10 days of submission of performance guarantee, failing which the performance guarantee shall be forfeited. Now, if your lordship comes to the next page, clause 8, my lord, clause 8.1, within 30 days, within 30 days after receipt of the letter referred to in clause 7.1, which I had just placed, the selected bidder shall deliver to the authority a performance bank guarantee. The lessee shall furnish a performance bank guarantee for a fixed amount equivalent to 50% of the annual leasehold rent, that is 6 months of monthly leasehold, valid for a period of 8 months from the appointed date, in as quoted in annexure 2, furnished in the form of bank guarantee. But then the relevant provisions follow, my lord. Those are perhaps not relevant at this
So the
juncture.
agreement was not executed.
Agreement was not executed.
You submitted the performance guarantee.
But
Now you are taking, they are taking the benefit ground that there is a dispute.
But in the letter, termination of my letter of acceptance, my lord, no reasons have been cited.
Subsequent it was in.
But subsequently, eviction notice, my lord, they say that the competent authority is neither here nor there. They bring in a competent authority that you have not been granted extension. Reasons have been cited, my lord. They can't improve their case at a later stage.
With regard to the this you are having the established petrol pump.
I'm running the petrol pump as well as the WSF. Nowadays, lordship knows there are food outlets and refreshment outlets that are there.
Including all three or one?
All both petrol pump and adjoining.
You occupied all.
No, I am in occupation of Lot A only.
A only. That's
Lot B, my lord, they have till date not been able to give possession.
B and C not given.
Because the stand that they take now, that the Lot B, there is a passageway at the river side of the plot, which they want to encroach now. They want to acquire now, not encroach, acquire now, and after completion of everything, then only they can hand over the site to us. But there was a joint survey report, my lord, which was done at the instance of the respondent only. By their, he had filed a report, my lord, which is very important, which I may place now, my lord, which is at page 253 of the affidavit, my lord, which they have disclosed. 253. This is their surveyor who had carried out and given an opinion. But this is the later dated report dated. The report date
17 January.
10th of January. Reference
17 January.
17 January. Yes, I'm sorry, but with reference to the referred mail, this is to say that the joint survey of WSA was conducted on 16/10/2024 in presence of independent engineer representative as such and such. In the survey, independent engineer was of the view that the measurement should be done up to the row. Row means lordship right of way. But HPCL representatives took the measurement up to the inner line of the tow line of the service road only. So the area came out to be 4.69 hectares only. Well, so as per their measurement, my lord, there is a discrepancy. It's not 5.76. As per CA, the area should be taken up to the row which comes to 5.79. The HPCL format is reviewed and independent engineer's observation is noted in the last column. Well, part A, my lord, which I showed in the drawing, my lord, that is the area of 2096 area. Well, part B and part C, which are in dispute, my lord, there's a pond. Part B, if your lordship sees the description, pond before ingress of the outlet while traveling from Kolkata. But the next column, if your lordship sees, my lord, NHAI have to level the pond, put up the boundary wall, and provide entry exit to the service road. But now the independent engineer's view, 1.77 HA area is inside the existing service road. New boundary wall should be constructed out of the old service road on the road. Now, similarly, if your lordship comes to part C, which is 1.418, pond after egress of the outlet while traveling from Kolkata. But the independent engineer's view is 1.418 area inside the existing service road.
Correct. So
Same.
what can be done with regard to
But
the
now,
two-
if your lordship sees the next,
the two
next-
plots are not in fully encumbrances, what you will do?
but that is why I had written to them that allow me to execute in respect of plot A, where I am already running a petroleum. But I can't outstay arbitrarily in that fashion manner. But because they knew very well while floating the tender. My if your lordship comes to the next page, which is the most vital part.
Yes.
In view of above, independent engineer is of the view that the present boundary wall of 2.09 hectare may be considered for signing of the agreement, and in future the rest area from such and such width should be considered to form service road, age plus road. This is for information and selection. But I all along was suggesting to them that till you clear out plot B and plot C, execute plot A, but which they could not do so. And that is the whole and sole reason there is an ongoing dispute with a third party concessionaire, and that is why they could not firstly give away possession to me, they could not surround the area with the boundary wall, and as a result, they could not execute the agreement. Now, at this juncture, my lord, can I be arbitrarily outstayed? That is the question, my lord. But two clauses, my lord, of the tender, my lord, I wish to draw your lordship attention to. This is tomorrow. But 1.3 of the request for proposal of the tender, my lord. I reply to pre-bid query.
Yes. Which page you are referring?
But page 31 of the writ petition, my lord. But 1.3, it's at the middle of the page. The authority shall
Page.
page 131 of the writ petition, my lord. But it's the starting of the tender, my lord.
Hmm.
But 1.3, my lord,
Hmm.
the authority shall provide the lessee with the sites at as is where is basis for development of mandatory fuel and non-fuel facilities with work including but not limited to development of common user facilities such as parking, etc., such and such. But this, they might be taking a point that it was offered and as on their own basis. But based on this, my lord, there was pre-bid queries which were being raised by us. My lord. If your lordship sees their reply in the pre-bid queries, my lord, which is at page 186 of the writ petition, my lord. (187) is the relevant part, my lord. If your lordship sees refer point 1.3 of RFP. But we had raised a query that RFP mentioned that authority shall provide the lease with the sites at as is where is basis for development of mandatory fuel and non-fuel facilities with work, including but not limited to development of common user facilities such as parking, washroom, etc. In addition to the master plan and specific layout, facade design, building construction, HA such and such, which has been made the part of the tender documents, it is to be construed that NHLML shall not level the land to the road and provide the boundary wall fencing at the demised land. Well, kindly sees the reply. The concerned sites are constructed sites which shall be provided as is where is basis, and authority shall provide entry, exit, access lanes to WS. That is not been provided. The demised land shall be provided at the level of entry, exit, access lands to the demised land. But they reply that they shall level the land and provide me entry exits. That they have defaulted in done so. But if your lordship comes to further down to the next page, my lord, but these are all, my lord, as far as the facts are concerned, my lord.
Yes.
Okay.
Next.
Well, point the other query, my lord, 0.7. এটা তো ঠিক আছে, এটা তো ঠিকই আছে। But I did not place the series of documents that I have written to them. Multiple letters I have written to them asking for them. But two judgments, my lord, I wish to place, my lord. 2010 টা আগে। Well, the first judgment that I intend to rely on is reported in 2010, Volume 1, Supreme Court Cases, page 655. Paragraph 11, my lord. Well, this is a similar contention that was being raised here. Mr. Amit Dawel, learned, paragraph 11 I was placing, my lord.
Yes.
Mr. Paragraph says, 10 says, we have heard, paragraph 11, Mr. Amit Dayal, learned counsel for the appellant corporation, submits that the respondent accepted the plots on as on where on basis. Therefore, the appellant corporation cannot now permit the respondent to wriggle out of a confirmed bid on the ground that there is no independent road to the unit. The learned counsel further submitted that it was for the respondent to make necessary inquiry with regard to the existence of the three column rasta with the revenue and other authorities. According to the learned counsel, the entire documentation which had been provided at the time when the loan was sanctioned clearly indicated that there is a three column. But the next paragraph, lordship comes to pay paragraph 14, my lord. On the other hand, Mr. Vimal Chandra Dave, learned counsel for the respondent, submits that the judgment of the High Court is self-speaking and it is not open to challenge on any of the grounds pleaded by the appellants. He submitted that the appellants cannot be permitted to take advantage of their own wrong. They have misled the respondent into making a huge deposit for a plot of land which was not suitable. Without an independent passage, the land could not have been used as a manufacturing unit. The appellant corporation ignored all the objections raised by the respondent with regard to non-existence of the independent approach road. But now the relevant portion, my lord, is paragraph 22. 22. 22. We see no reason to take any different view, my lord. But the High Court had order of the High Court was being challenged. We are also of the opinion that the division bench was justified in further concluding that in law, the appellant corporation undoubtedly has the power to forfeit the earnest money, provided there was a failure on the part of the respondent to make the deposit. The division bench, however, observed that the respondent was dealing with the instrumentality of the state. He was entitled to legitimately proceed on the assumption that the appellant, a statutory corporation, and instrumentality of a state shall act fairly. The respondent could not have suspended that he would be called upon to pay an amount of 50 lakhs without even being given even a proper passage to the unit that he was buying. We are of a considered opinion that the respondent had deposited the sum of rupees 2.5 lakhs on clear understanding that there would be an independent approach road to the unit. This is understandable. Without any independent passage, the plot of land would not be more than an agricultural plot, not suitable for development as a manufacturing unit. We therefore do not find any substance in the submission made by the learned counsel for the appellant. Now, next, your lordship comes to paragraph 25. But there are provisos which are indicated just below that, my lord. A mere perusal of the aforesaid provision will show that it was incumbent upon the appellant corporation to disclose to the respondent about the non-existence of the independent passage to the unit. It was also the duty of the appellant corporation to inform the respondent that the passage mentioned in the revenue record was not fit for the movement of the vehicles. The appellant corporation also failed to produce to the buyer the entire documentation as required under section 55 of the above section. We are therefore satisfied that the appellant corporation cannot seek to rely on the aforesaid provisions of the Transfer of Property Act. But now the concluding paragraph, my lord, 29 and 31. The next page, my lord. In any event, the fact of this case as narrated above would clearly indicate that the respondent had made all necessary inquiries. It was the appellant corporation that failed to perform its obligation in giving a fair description of the property offered for sale. Now, paragraph 21, if I may take your lordship to, it appears that the judgment of the High Court had been stayed by this court on 2/9/2002. In view of the dismissal of the appeal, we direct that the forfeited amount be refunded to the respondent with 12% interest till payment. The amount be paid to the respondent within a period of 2 months from producing the certified copy. We also direct, my lord, there was a cost that was been awarded. But at this juncture, my lord, what we are seeking, my lord, but I have taken instructions, my lord, subject to what my learned friend says, my lord. Without prejudice, my lord, we are ready to execute the agreement for the entire period. Let them take time and hand it over. Because lordship considers the situation, my lord, a petrol pump which has been
The disputed property.
but without
How
prejudice.
they can execute the
They cannot. And at the same time, they also can revoke my LOA.
correct. That's correct.
That is an added instruction that I've taken. If it comes to a logical conclusion, to be very fair also to your lordship, my lord, so it comes to a logical conclusion, my lord. One of the other judgment which I intend to rely on
As it is name.
is reported in 2000. 2016, volume 1, SCC, page 724. But this is on a proposition, my lord, when they have not cited any reason of termination of LOA, but they can improve their case at a later stage by issuing of subsequent documents, my lord. Now, paragraph 4, if I take your lordship to,
Reference to what?
2016, volume 1, SCC 724. 1 SCC. Now, paragraph 4, if your lordship comes to, there can be no gainsaying that every decision of an administrative or executive nature must be composite and self-sustaining one. In that, it should contain all the reasons which prevailed on the official taking the decision to arrive at his conclusion. It is beyond cavil that any authority cannot be permitted to travel beyond the stand adopted and express it in the impugned action. If the precedent is required for this proposal, it can be found in a celebrated decision titled in Mohinder Singh, my lord, where lordship is aware of, my lord. It has been quoted, my lord, the second paragraph 8 of that judgment has been quoted. The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of an affidavit or otherwise. Otherwise, an order bad in the beginning may by way it comes to court on account of a challenge gets validated by additional grounds later brought out. But the next also paragraph has been set out, paragraph 9. Public orders publicly made in exercise of a statutory authority cannot be construed in the light of expressions subsequently given by the officer, making the order of what he meant or what was in his mind or what he intended to do. Public orders made by public authorities are meant to have public effect and are intended to affect the actings and conduct of those to whom they are addressed and must be construed objectively with reference to the language used in the order itself. But paragraph 8, my lord, is a relevant paragraph, my lord. In the impugned judgment, the High Court has rightly concluded that no sustainable justification and rationalization.
Where from
No, paragraph 8, my lord, at the next page, my lord.
Yes.
In the impugned judgment, the High Court has rightly concluded that no sustainable justification and rationalization was recorded in writing at the relevant time for ordering the re-auction of only two subject properties, my lord. But rest discusses, my lord, the facts of the matter, my lord. But, the next judgment, my lord, which I intend to rely on. Judgment or not? কোন proposition? For 2024 SCC online Supreme Court 840. 2024 SCC online 840. But this is based on a proposal, my lord, no authority can benefit or take benefit of its own wrong. But the relevant portions, my lord, starts at page 7, my lord, paragraph 18 onwards. Paragraph 18, if I may please, my lord. The situation at hand is squarely covered by the Latin maxim, nullas commandam capere protest de injuria su proprietaria. But after reading this judgment, I went through the legal dictionary and tried to find out the true meaning, my lord. Which means that no man can take advantage of his own wrong. This principle was applied by this court in the case of Union of India versus Major General Madan such and such. One of the relevant paragraphs have been quoted. In this behalf, the maxim nullas commondium such and such, meaning no man can take advantage of his own wrong, squarely stands in the way of avoidance by the respondent as he is estopped to plea bar of limitation contained in section 123 of Bloom's legal maxim. It is stated, it is a maxim of law recognized and established that no man can take advantage of his own wrong, and this maxim, which is basically on elementary principles, is fully recognized in courts of law and of equity, and indeed admits of illustration from every branch of legal procedure. The reasonableness of the law being manifest, we proceed at once to show its application by reference to decided cases. It was noted that therein that a man shall not take advantage of his own wrong to gain a favorable interpretation of the law. In support thereof, the author had placed reliance to what that has been stated, my lord. But paragraph 19 also sets down the same facts, my lord. The next page, my lord. It is beyond cavil of doubt that no one can be permitted to take unfair and undue and unfair advantage of his own wrong to gain favorable interpretation of law. It is a sound principle that he who prevents a thing from being done shall avail himself of the non-performance he has occasion. To put it differently, a wrongdoer ought not to be permitted to make benefit of his own wrong. The conduct of the respondent petitioner is fully covered by the aforesaid provision.
Yes. That's all.
That is all, my lord. But there was another circular, my lord, which is perhaps I will just take your lordship, my lord, to page 79, no? Or page 79 of the affidavit in opposition, my lord. But this is a circular which they have disclosed, my lord, dated 5th July 2023.
Yes.
By this circular, NHAI has come to a conclusion that the concessionaire will not carry out any activities inside the tender plot. Perhaps because of this circular, it had culminated to a institution of some legal proceedings by which they were prevented from doing it. But the relevant clause, if I may place, my lord, kind attention is invited to serial 10 of the policy circular dated such and such 2022, standard operating procedure for award of wayside amenities along national highways. It has been advised that construction of wayside amenities may not be included in the scope of road contractor. So concessionaire is a road contractor who was earlier in possession, my lord, for greenfield expressways and brownfield legal national highways. The construction of boundary wall approach roads, leveling, filling can only be included in the scope. So this perhaps had culminated to a dispute between the concessionaire and the NH highway, for which they prevented to run. But these are more or less the facts. But if anything, I'll add any reply.
Yes.
My lord, I start today, but I will take a little instruction and again come back. My lord. I will take little instruction.
See, you have placed the tender and two are the disputed. One is not disputed and is having the petrol pump over there. How we can be evicted now?
Petrol pump. My lord, that lease agreement has.
But the tender again, you issued the tender. He was the highest bidder,
No, I
and
didn't.
it has been accepted by you. Now you are telling that the two property are disputed with regard to the other property has.
As soon to that extent, my lord, limited submission. As soon as he or she, my lord, participate in the subsequent tender process, first tender code,
Correct.
he cannot claim on that. Now, the second tender, my lord, whether rightfully cancelled or not, that's another issue. But for that, he cannot say that I will continue in regard to the first tender.
Not continuing, because he was continuing. You have issued the tender. He has participated. He has the highest bidder. He has deposited the performance, including 3 plots. And subsequently, the agreement was supposed to be executed. Agreement could not be executed. There is a dispute.
But one clarification, my lord, I was not in occupation by way of a tender, by way of a lease.
That's
that-
true,
that-
but that expired
Correct.
in 2023.
Correct.
August.
So now, can you say at this is okay, there is a dispute, you can sort it out. Now you can turn turn around.
My lord, probably that is as is where is basis.
Correct.
So he has to accept that.
Hmm.
On that.
Hmm.
He cannot raise any dispute in regard to that.
Correct. So you have clarified that in the query in the pre-bid meeting. In the pre-bid meeting, your authority has clarified that.
That I have seen, my lord.
1.3 clarified that.
My lord, I have to take little instruction on this and come back.
Take that.
And on Monday, you'll also keep it, I will do it.
No
It
problem.
is under the same head.
Take the instruction with regard to that.
And
Okay.
if they, upon instruction, if I want to make submissions, I will go and make.
Now, learned counsel for the petitioner has concluded his argument. Learned counsel for the respondents prays for time to take instruction. According case is adjourned. Let the matter appear. Wait,
My client,
just
it should
20
be limited.
seconds. 20 seconds.
My learned friend is ready and willing to as is.
Sir, I had put in a
that's
proposal
why.
to put an end to it. To
Because
just-
that's why he
that's-
is harping upon that 2 clauses and he's harping upon his possession. And with regard to the 2 disputed, you go and you fight.
I will take instructions from
Fight with that.
PB requests and then I will come.
Sir, the interim order was still today, my lord. Maybe.
22nd July 22, within 10 matters. Interim order is extended till 24th July or until further order.
No, it will be on Monday,
No, to Wednesday.
Wednesday. No, kindly keep it in the first 5 year losses
10 matters within 10 matters.
so that your losses can take it up.
I'm obliged, my lord.
Lord, this is a matter, my lord, regarding my lord, your lordship, my lord, statement, my lord, comes to my lord, page 42 first. This is my lord, regarding my lord. My lord, this is my lord, letter of intent, my lord, issued by the my lord, Indian Oil Corporation Limited.
Yes.
It is 762024. My lord, your lordship, my lord, kindly see, my lord, clause number 1. It says that you have offered a suitable land measuring about such and such at Dag number such and such as indicated by you in the application for development of the subject retail plot. You have to make available the said piece of land and submit all relevant land documents in respect of the same within 2 months from the date of this letter for the development of the retail outlet by the Indian Oil Corporation, failing which letter intent will be withdrawn. Now, so far as this land is concerned, my lord, I purchased the land from the Milord erstwhile landlord. Milord kindly turns Milord page 46. Page 46, Milord, is my deed.
Yes.
Now, Milord, first page is Milord Bengali, Milord, kindly skip Milord page 47. Milord, purchaser is Milord C. Anand Nagaral, Milord, petitioner before your lordship.
Yes.
Now, Milord, kindly turn Milord page 49. Page 49, Milord, last 4-5 lines I am just reading. It is hereby declared, I hereby declare that, as you also got in, Milord, that I have no objection stroke claim to the Borga record in respect of 15 decimals of land sold by me and the total 37 decimals of land purchased by you. In this regard, being of sound mind, willfully and knowing and without any coercion or influence from others, I have fully understood the terms and of this contract and execute this document in presence of witnesses on 17th March corresponding to 1st of February 2012. Now, the Borga recording which was there, the Borgadar who sold the land to me. He said, he has no objection so far as his Borga is right is concerned. Now, kindly have a look. Just I place 2 documents. Kindly turn to page 93. Now, prior to that, you lost kindly turn page 89 once.
Yeah. Page 81.
89. 89. Translated copy, you lost would get in at page 90. 90. Now, you lost would find that is Dag number 149, left hand second one. Now, land measuring about 35 decimals. Now, it is recorded Sanjeev Kumar Sarkar as Borga.
Sanjeev Kumar, father of Virendra.
He was a landowner, from whom I purchased the land. I have shown the deed, which is appearing at page 40. I shown to your lordship page 49.
Yes.
Now, kindly see 2 documents. I will show to your lordship.
No, page 90.
90.
90 is details of the owner of the property, Ananda Agrawala.
Yes.
Correct.
Yes.
Father's name so status is Rayat.
Rayat.
Correct.
Rayat. His status is Rayat.
Mm-hmm.
And so far as Sanjeev Kumar Sarkar is concerned, his name has been recorded as in this as Borga.
Where is that?
Your lordship would get it and page 49 and then translated copy. Now, your lordship kindly.
Where is it recorded Borga?
It is there is some mistake in the translated copy. Page 89. Your lordship kindly turn page 89.
Yes.
Your lordship would find the Borga Dung. Page 89.
Yes.
Borga Dakhol. Actually, in translated copy, it is missing.
Okay.
Now, kindly turn next. I will just submit to your lordship. I applied for deletion of the name of Borgadar. It is admitted fact, the person from whom I purchased the land, he said he is having no right and interest. He was trying to extinguish his right as Borgadar. Now, in that respect, there are 2 reports. Kindly turn page 100 once. Prior to that, may I just place page 99.
Yes.
Page 99, this is a communication of 3rd of September 2024 by the Block Land and Land Reforms Officer Nakashipara to the Additional District Magistrate, District Land and Land Reforms Officer.
Correct.
It says, in connection with the subject mentioned above, this is to inform you that one Anand Nagarala applied for deletion of Borgadar in respect of below scheduled land, Moja such. It appears from the LR that the plot number 149 is recorded in the name of Anand Nagarala and Borga noting in the name of Sanjeev Kumar Sarkar, son of Virendra, is also found.
Yes.
It reveals from the available that Anand Nagarala has purchased the suit land from Sanjeev Kumar Sarkar, who is a Borgadar of the suit land. Now, next page, page 100. Your lordship, can you see page 100? This is also internal communication between District Land and Land Reforms Officer to the Block Land and Land Reforms Officer. It says, regarding the prayer of Anand Nagarala for correction of record. In continuation of the above noted subject and reference, the original case record is sending herewith to verify the documents and to opine whether the case is fit for initiation of proceeding under section 20B5 or not. Well, I will just refer to you, see what is the 20B5. Now, we'll next page, page 101. Page 101 says, Lord, with reference to the above noted subject, this is to inform you, Anand Agarwala purchased the suit land from Sanjeev Kumar Sarkar by deed number such and such, and the said Sanjeev Kumar Sarkar purchased the land from Gaur Gopal Vishwas by deed number such and such, ADSR Bethorori. At present, it reveals from the CLR that record has been framed in the name of Anand Agarwala, measuring about 34 decimals of Borga, noting in the name of Sanjeev Kumar Sarkar. Applicant desires to establish a petrol pump on the suit land and contiguous other plots. On verification of the land, it reveals the suit land will not be affected by the proceedings under section 20B5 of the WBLR Act, and this is for your kind information and necessary action. Now, we'll kindly have a look at what is the section 20B5. Page 51 of this book. Page 51, 20B, it says surrender or abandonment by Borga. If a Borgadar surrender his right to cultivate in relation of any land cultivated by him as a Borgadar, or voluntarily abandon cultivation of such land, owner of the land or the Borgadar or any person may give information in writing of such surrender and abandonment of the officer of the authority appointed under subsection 1 of section 18, having jurisdiction in the area in which such land is situated. Now, Millard, kindly straightway comes to Millard 5. 5 says that any contravention of the provisions of subsection 3 or subsection 4 shall be an offence punishable with imprisonment for a term which may extend to 6 months with fine or may extend to 1,000 rupees or with both. So, Millard, 20B5 says that if it is a violation. So, Millard, it is a case, Millard, the page 101 says that it is not covered under section 20B5.
Because he is giving the no objection for
This is my case, Millard. What they are doing, they are not, Millard. What is my prayer, Millard? Can I have a look, Millard? Just my prayer. I need NOC, Millard, from district magistrate for the purpose of setting up this. Otherwise, Millard, what is the recording is there, Borgadar. That's why they are saying, no, I will not give permission. Can you see, Millard, what is my prayer? Page 23. Page 23, first prayer is
objection certificate.
Yes. No objection certificate in favor of the petitioner for establishment and commissioning of the proposed retail outlet dealership of IOCL immediately on the basis of the report submitted by the BL and LRO Nakashibara Responsible says. That is a 101 page. So I need, Millard, only this one. Nothing more, nothing like. My case is, Millard, based on that. Page 101.
Yes.
Millard, so far as, Millard, report, Millard, your lordship has called for the report. The report has filed by the respondent number 7. Now, in the respondent in the report, Millard, respondent number 7 is, Millard, relying on, Millard, section 14Y. Now, let us see, Millard, section 14Y once. Kindly have a look, Millard, section 14Y, page 36. 14Y says, Millard, limitation on future acquisition of land by a Rayat. If at any time after the commencement of these provisions of this chapter, the total land owned by the Rayat exceeds the ceiling area applicable to him under section 14M on account of transfer, inheritance or otherwise, the area of land which is in excess of the ceiling area shall vest to the state, and all provisions of this chapter relating to ceiling area shall apply to such land. Next, provided that if the state government, having regard to all the circumstances of the case on the basis of the project report filed by any person, is satisfied that such person requires land for the purpose of establishment, mill, factory, workshop, livestock, breeding farm, poultry farm, dairy, fishery, township, transportation, terminal, logistic, industrial and industrial hub, warehousing, tea garden, agro industries, power plant, power transmission, distribution substation, film city, tourism, and all these things. Now, Millard, next you will also find for the purpose of his future expansion of such mill, factory, workshop, livestock, breeding, poultry farm, and all these things. And Millard, previous permission in writing of the state government on such terms and conditions is may be managed the state government by the rules prescribed acquire and hold such land provided that land person having been permitted by the state government to establish the industrial park, industrial hub, or industrial estate, financial hub, logistic hub, biotech park, or food park township, or shall utilize such land or lease out or transfer freehold basis on payment of the prescribed fees to the land and land reforms such and such and such. Now, my lord, this section 14Y, my lord, in my responsible submission, is applicable only when a person, my lord, holding the land more than ceiling area. Now, my lord, kindly have a look at what is the ceiling area, so far as I am concerned. Kindly see, my lord, section 14M,
14M.
page 28 of this book. Ceiling area says, my lord, the ceiling area shall be, in case of a riot, who is an adult unmarried person, 2.5 standard hectare. In case of a riot, who is sole surviving member of a family, 2.5. In case of a riot having family consists of 2 or more or not more than 5, then 5 standard hectare. Now, my lord, 1 standard hectare is equal to, my lord, 2.471 acre. Now, my lord, 2.471 acre means, my lord, in multiplied in 3, but it goes to, my lord, more than 10 bighas. My lord, more than, so far as
What is your land?
my land is, total land is 35 decimals. Total land is 35 decimals, and so far as Borga is concerned, my lord, there is 15 decimal. It is not even coming, my lord, I am very much within the ceiling area, very much. Even if I consider myself as an independent person, my lord, unmarried person, though I am a married person, my lord, having children, I will be coming on a cross C. But even if I consider, my lord, 2.5 standard hectare, then also, my lord, 2 standard hectare multiplied into, my lord, 2.471, but it comes more than 5 acres, and 5 acres means, you know, 1 acre is 3 bigha, that means 5 into 3, 15 bigha, and 1 bigha is equal to 33 decimal. So, it is, I am very much within the ceiling limit, very much within the ceiling limit, and I will not. Their main contention is this, that I am beyond the ceiling limit.
So what is the total area?
My area is 15 decimal.
15.
15. Total is 35 decimal, the total purchase, and so far as Borga is concerned, that is only 15 decimal. And kindly have a look, only few pages I will show to your lordship. Kindly turn page 112 once. All the statutory authorities will not have given permission.
No, I hereby declare that I have no further objection claims of the Barga record in respect of the 15 decimal.
Yes.
Of the said land sold by me, and the total 37 decimals.
37 decimals. Total land, his land is,
total is to be taken into consideration.
even if total is to be taken, then it's also within the ceiling limit.
No. How?
Yes. The ceiling area is not your lordship.
Ceiling area kindly come to the C.
C.
In case the riot having family consist of 2 or more.
Yes.
But you are having the family.
Yes.
Okay.
Then we have 5 standard hectare.
5 standard.
5 standard hectare means, my lord, it comes to 12.35 acre.
5 standard.
1 standard hectare equal to 2.471 acre.
Okay.
Now, it comes to 12.35 acres. And 1 acre means 100 decimal 1 acre. That means, it comes to 1235 decimals. I think Mr. Mishra will not dispute that. 1 acre is equal to 100 decimal. 1 acre is equal to 3 bighas.
What the report says?
A report is saying, that is 14Y. They are specifically, may I just place the report? Kindly see, page 2, paragraph 4(2). It says, the consequential clearance said to be connected with the proceeding under section 20B5 of the WBLR Act. The reliefs paid, including the prayer for direction upon the respondent to forward the clearance by deleting the Borga notion, are reliefs which squarely covers within the domain of land reforms, so that the expression used in the special legislation noticed below. Now, what they are taking one point. The point is this is in respect of I am asking for deletion of the recording as Borgadar in respect of the thing which is covered under the West Bengal Land Reforms Act. Now, in view of the West Bengal Land Reforms and Tenancy Tribunal Act, there is a provision section 2R. It says that there are specified act. The West Bengal Land Reforms Act is one of the specified act, and even if it is a specified act, then I have to go to the West Bengal Land Reforms and Tenancy Tribunal. Right. Now, your lordship will kindly consider so far as my case is concerned. In my case, two things are there. One is LOI issued by the Indian Oil Corporation. Indian Corporation is going to terminate my LOI. And on the other hand, my lord, my LOI is going to be terminated for non-furnishing NOC by the distinguished estate. Now, my lord, your lordship knows, my lord, there is a law term called, my lord, dominance litis. Now, my lord, if my lord, the two jurisdictions are clubbed, one is, my lord, West Bengal Land Reforms Tenancy Tribunal, and another is before this honorable court. Now, my lord, your lordship had the occasion, my lord, to decide it on several occasions that I can approach any of the forum. And section 17 of the CBC of the gives me some right also. So, my lord, and so far as tribunal,
That's correct, but unless and until the authority will not take the decision for the conversion of that.
now, my lord, so far as my lord, page 101 is concerned, page
Yeah,
101 is
101.
absolutely in my favor. Page 101, they are saying, my lord, it is not covered under section 20B5. If it is not covered under section 20B5, that means they are proceeding on the basis of page 49. And my lord, simple recording is there, Borgadar. But the ownership lies with me. And my lord, there are judgment. One judgment I can cite to your lordship. The judgment is this: once the person concerned sold the Borgadar sold the land to somebody, the Borgadarship goes. Well, this is the my lord, settled position of law. My lord, kindly have a look. My lord, this judgment of the single judge of this.
Borgadar land can be can the sale deed can be executed.
Yes, my lord, if Borgadar sold the land to somebody else, now, my lord, then Borgadarship goes. And here, my lord, Borgadar sold the land, and my lord, he is also relinquishes his right. And here, your lordship, my lord, can you see paragraph 23, 24, and 25? Three paragraphs I will just show to your lordship.
23.
23. Paragraph 23, my lord, your lordship can come last from bottom, my lord, sixth line from bottom. Apart from the same. May I just place?
Yes.
Apart from the same, once the lesser right merge with the higher right, there is a complete erosion or diminution of the lesser right, as mutually inconsistent right cannot operate simultaneously. In other words, a person cannot remain Rayot as well as Borgadar under himself, or can circumvent the provisions of law by a clandestine agreement or transaction. The moment the right to cultivate of the land by the Borgadar ceases on acquiring the right of a Rayot, mere erroneous entry in the record of right does not render the property till encumbered when both rights cannot exist mutually. Next, paragraph 24. It is treat law that right to cultivate the land by Borgadar is lesser right than the right of a Rayot, and the moment such right merge with the right of a Rayot, it is ipso facto extinguishes the right of a Borgadar, and the nature of the property remain as Rayati, whole land without any existence of Borga therein. The moment the purchase was made in the year 1967 by the Borgadar in favor of the respective wives, the right to cultivate the land as Borgadar extinguished, and the subsequent purchase by the father of the petitioner in the year 1974 did not bring any change in such position. In view of the above, there is no hesitation in my mind that the petitioner satisfies the clause pertaining to the ownership of the land, as the right of Borgadar was not subsisting as on date, and mere erroneous recording of the record of right cannot act as a deterrent to the applicant and operate prejudicially to his interest. So, this point has been settled by this honorable court from time and again, and more so the person who is selling the property, my lord, he is saying, I have no objection at all if my right extinguished. And my lord, more so, in this matter, you will also finally see paragraph 30. In this matter, it said, my lord, authority is directed to proceed the said application in the light of the observations recorded therein, and the entire exercise shall be completed within 4 months from the date of communications of this order. So, my lord, this similar point was raised before this honorable court time and again, and this honorable court has said that once the Borgadar, my lord, purchased the land from his owner, the Borgadar is extinguished, and subsequently, when I purchase the land from him, then, my lord, the property becomes, my lord, secular property. So, my lord,
yes.
My lord, sorry, my lord. My lord, first I will raise the issue of maintainability, my lord. How this application is maintainable before the honorable court, my lord. If my lord may kindly takes my objection, my lord. Report, my lord. Sorry, my lord. This is a report in form of objection. My lord may kindly takes page 2.
Yes.
Subparagraph 2, my lord.
Yes.
Roman 2, my lord. My lord, the consequential clearance said to be connected with the proceeding under 20B5, which they are claiming, my lord, of the West Bengal Land Reform Act, the reliefs prayed for, including the prayer for a direction upon the respondent number 5 to forward clearance by deleting the bargain notion. My lord, this is their primary prayer, to delete the bargain notion from the record of rights, my lord. Now, my lord, all these falls within the domain of land reform, my lord. This falls within the domain of land reforms, my lord.
Correct.
So, my lord, LRTT is the forum where they must go and agitate this, my lord, not before this honorable court. This is my most humble submission, my lord.
No, that's why. What is the prayer? What is the petition? What is
My
the
lord,
prayer?
kindly takes
They
prayer,
are
my
not
lord.
asking to allow. They are asking kindly see
My lord, my lord, may I place the prayers?
respondent number 4 to consider. So they are asking for the direction upon the respondent number. Who is the respondent number 4?
My lord, kindly allows me a moment.
District magistrate.
My lord, even DM is not the authority to consider, my lord. It has to be done by the BL and LRO, my lord.
Okay.
Block land and land revenue officer will do this, my lord. So this prayer is itself.
Okay.
Now, my lord, this is a simple case, my lord, where the prayer must go before the land reform tribunal for adjudication, my lord. If they want to do that, my lord. Now, my lord, I may kindly take 20B, my lord. They say they want to set up a petrol pump, my lord.
Yes.
Twenty B white.
20B5.
My lord. Which one? Open. So, my lord, 20B speaks about surrender of abandonment by the Borgadar. Now, my lord, 5 they have stated before, my lord, so I must not reproduce it, my lord. Now, my lord, section 5 of 20B, my lord, which I have placed, my lord. My lord, section 5 of 20B of the Act, my lord, from the rigor of the offence otherwise created by subsection 3 and 4 of the section 20B, the utilization of land cultivated by the Borgadar for any of the purposes referred to in the first provision of
Which section you are referring?
My lord, 20B5, 3, 4, my lord, in all, my lord. 20B5, which has already placed.
20B5.
Hmm.
Any contravention?
For any of the purposes referred in the section 14Y, my lord. Subject to the payment of compensation to the Bargadar under the Land Acquisition Act 1894 and the rules made thereunder.
Correct.
My lord, my submission is the benefit of this provision is conditional, my lord. Upon, my lord, in the first instance, upon the land in question being intended to be utilized for a purpose recognized under the first provision of section 14Y.
No, here the first question is that, okay, the Bargada has sold the land.
My lord.
He is purchaser. Whether the land continue as a Bargada in terms of the judgment.
Until and unless not deleted.
In terms of the judgment of the.
My lord, kindly sees the 23 first portion, my lord, the judgment which he has referred to, my lord. By Honorable Justice Tandon, my lord. My lord, from the top, my lord, 23 from the top. Paragraph 23, internal page, my lord, 5.
Yes.
From the meaningful reading of the provisions contained in the chapter 3 of the said act, it is explicit and clear that though the right of cultivation of Bargadar is heritable one and not transferable, yet such right can be terminated by order of the authority of the state government under section 18 of the act.
Correct.
So it is clear, my lord.
Correct. Then the concept.
The concept of termination of right to cultivate by the Bargadar stands on a different pedestal footing than the merger of such right into a higher right by operation of law.
Correct.
Now, my lord, this case, if a husband cannot bestow right of cultivation upon the wife as a Bargadar, it is not a case, my lord. It is a clear case of sale of land, my lord, from one person.
Correct. Then
I'm placing it.
Can we come to that?
The moment the Bargadar purchased the land from the Rayat in the name of the wife who stepped into the shoes of the Rayat, the said Bargadar cannot satisfy the definition of Bargadar enshrined under section 22 of the said act. Apart from the same, once the lesser right merger into a higher right, there is complete erosion and or diminution of lesser right as mutually inconsistent right cannot operate simultaneously. In other words, a person cannot remain Rayat as well as Bargadar under himself, nor can circumvent the provision of law by clandestine agreement. And Namalat, this is kindly see that a person cannot remain Rayat as well as Bargadar under himself, nor can circumvent the provisions of law by clandestine agreement. Namalat, this is my submission. This is a clandestine agreement between the erstwhile owner and the present petitioner, my lord.
No, it is okay.
My lord, I am completing the line, my lord. And our transaction. The moment the right to cultivate the land by the Bargadar ceases on acquitting the right of a Rayat, mere erroneous entry in the record of right does not render the property still encumbered when both the rights cannot exist mutually. My lord, still there is no right, my lord.
Yes.
He has his land where he is a Rayat, my lord. Now this land still is in the name of Bargadar, my lord. So how this judgment help him, my lord?
Okay.
Now it is, now the first part of the judgment says, my lord, that though the right of cultivation of Bargadar is heritable one and not transferable, my lord. Now, my lord, he says that opening of a petrol pump, if my lord may kindly takes 14Y. Subsection 1, my lord.
Yes.
What are the purposes that are set out there, my lord?
Correct.
Now, my lord, starts with limitation on future acquisition of land by a Rayat. If at any time after the commencement of the provisions of the chapter or the total area of land owned by a Rayat exceeds the ceiling area applicable to on him under section 14M on account of transfer, inheritance or otherwise, the area of land which is in excess of the ceiling area shall vest in the state, and all the provisions of this chapter relating to ceiling area shall apply to such land. Provided that if the state government, after having regard to all the circumstances of a case and on the basis of the project report filed by any person, is satisfied. Now, my lord, his project is, my lord, kindly keeps in mind, my lord, that his project is operation of a petrol pump. Project report filed by any person is satisfied that such persons requires land, A, for the purpose of establishing of a mill, a factory or a workshop, breeding, livestock breeding farm, poultry farm, dairy, fishery, township, transportation or terminal logistic hub, industrial park or industrial hub, warehousing, tea garden, agro industry, power plant or power transmission or distribution substation, film city, tourism project, educational and medical institution, biotech park, food park, port, airport, shipyard, including shipbuilding and shipbreaking, oil and gas products, pipe transportation, information and communication technology, ICT industry and information and communication technology, allied industry, or mining and allied activities. Now, my lord, B, for the purpose of future expansion of any such mill, factory, workshop, livestock, breeding farm, poultry farm or dairy, fishery, township, transportation or terminal logistic hub, industrial park or industrial hub, or industrial state financial hub, warehousing, tea garden, education, medical institution. Now, my lord, kindly mark this. Oil and gas products, pipe transportation, my lord. It says oil and gas product, pipe transportation, my lord.
Yes.
So a petrol pump, my lord, in my most humble submission, does not falls within oil and gas products pipe transportation, my lord.
Okay.
My lord, kindly text my report para 7 and 8, my lord.
Yes.
My lord, I have explained. In my report, my lord, I have put it. May I place it, my lord? Paragraph 7 and 8, my lord. It is humbly submitted that section 14Y of the WBLR Act is a statutory exception which enables a person to acquire and hold retained land in excess of ceiling area only upon by obtaining previous permission in writing from the state government and also the purpose specifically enumerated in the first proviso thereto. The said proviso exhaustively specifies the categories of the project purposes for which permission may be granted, namely an establishment of a mill, factory or a workshop, livestock, breeding farm, poultry farm, dairy, fishery, township, transportation or terminal logistic hub, industrial park or industrial hub or industrial state financial hub, warehousing, tea garden, agro industry, power plant or power transmission, distribution, substation, film city, tourism, educational and medical institution, biotech park, food park, port, airport, shipyard, including shipbuilding and shipbreaking, oil and gas products, pipe transportation, information and communication technology and ICT allied industry and mining and allied industry. Plain reading of aforesaid proviso shows that it is couched in exhaustive enumerated terms and does not employ any words of general extension such as and other similar purposes. Establishment and operation of a retail outlet, petrol pump, dealership does not figure anywhere in the said enumeration.
Yes.
So, my lord, it is some. Now, my lord, kindly takes page 10 of my report, my lord.
Yes.
Annexure R2, my lord. Now, my lord, this is the communication to the district land and land reform officer by the additional director of land records and surveys, West Bengal, my lord. May I place it, my lord? This is the report. Subject seeking instruction in connection with the applicability of section 20B5 of the WBR LR Act 1955 in respect of petrol pump. Now, my lord, in reference to the above noted subject under reference, this is to inform that the deletion of such bargadar under section 20B subsection 5 of the WBLR Act 1955 is possible only if the land is identified to be utilized for the purpose as a land down under first provision to section 14Y. However, the bare provision to section 14Y of the WBLR Act 1955 does not include such a purpose like petrol pump.
Okay.
So this is our reply to the said internal communication which they have relied upon in their application, my lord.
Okay.
So, my lord, my first most humble submission before my lord, that application is not maintainable, my lord. It must go before the West Bengal Land Reforms and Reforms Tribunal, my lord. Great.
Only one thing, Milord. Kindly takes Milord, the judgment Milord, which is relied upon Milord. That is Milord 2018 SSC Online Calcutta 117. Now, Milord, kindly see the paragraph 3. Similar facts, Milord, paragraph 3. The challenge is made to the decision of the Indian Oil Corporation Limited taken on 3rd April 2018, whereby and whereunder the candidature of the petitioner for selection of distributor under the Rajiv Gandhi Gramin LPG Vitarak scheme was cancelled on the ground that the land offered by the petitioner was in fact not encumbered land, as there was recording of Bargadar in the record of right. This was the subject matter of the writ petition. Can you see this is also the writ petition? WP 5521 W of 2018. Now, we'll kindly text paragraph 12 once. Facts more or less similar, paragraph 12. The petitioner says that once the Bargadar have acquired and or elevated their status as riots by purchasing the land through a valid deed, it ipso facto extinguishes such right and merges with the rights enjoyed by the riot. And even if there is no correction in the record of right, it does not change the character of the land or the right of the parties in relation thereto. So, Milord, even a Borgadar will purchase the land, so it becomes Milord a Borgadar ship goes Milord. And now, Milord, so far as Milord Mr. Mishra has submitted paragraph 7 of the report submitted by him by the BLRO.
Yes.
Now, Milord,
It is not the petrol pump.
14Y Milord does not apply. 14Y apply when I am holding the excess land beyond the ceiling limit. Then Milord 14Y will apply. Well, these are my sons. These are my sons.
Getting concluded, CM.
Deeply applies.
I am keeping this book.
Yes.
Grateful, my lord.
Thank you.
Deeply applies.
कॉल करो फिक्स मैटर है फिर 1 बजे तो पूछते क्यों
Lordship, item number 88 and 89 is also, I believe, SIR matter. 88 and 89, but it has gone.
Okay. Oh, some matter speaks. Call. Where is the matter? No.
SIR matter.
SIR matter नहीं है.
हाँ.
नहीं.
From item number 97.
तो फिर आगे बढ़ाना नहीं था matters. Why you kept all these things? Why you not come yesterday with the cost list? You are not stated this. You are not to run the court with this ACO?
Your Lordship, 97 is a matter where 43 petitioners have jointly filed a petition. This may be dismissed because it will be difficult.
I will dismiss.
Only with the liberty to file a fresh, Lordship.
On that day, I have given the liberty, but you have not taken the liberty. Now you are taking today.
I sought instruction, Lordship, and thereby,
Now, as per the
Lordship,
as per the prayer made by the counsel for the petitioner, writ petition is dismissed with the liberty to take file a fresh.
and Lordship, can we give the number to your Lordship so that the matter can be taken up?
What?
Monday যে দিন mentioning হবে ওই দিন mentioning দেবে।
Much.
98 page number, your Lordship, 18. ওটা খোলো না তাহলে।
Page number?
আর তোমারটা কত page?
98, who is appearing?
Well, I am appearing.
Page number?
18 is the prayer.
ঠিক করে দেখে নেবো। আমি অন্য petition দেখে বলেছি।
18?
না না না।
কি চাই? কি দেবো? কি 18 কি বলতে চাইছে? Malad, page number 18 is the prayer, Malad, and Malad, my application for appeal, Malad, it is, Malad, acknowledgement is at page 114.
Where is your appeal?
Malad, page 114.
The within 3 months. Yes, next.
কোনটা আছে 19? এটা 18 স্ক্যান করো। अब उनको ईमेल एड्रेस लिख के दो, नंबर। एफिडेविट सर्विसটা বাড়াও না, এটা অন্যটা।
This was next.
Appeal. Page number 20, your Lordship.
Page number 30. One three.
Where is the appeal?
Page number 13.
Huh?
13.
13, 1 3.
This was yes. Call the name.
Item number 5.
Call.
Against it, because pilot is a little.
No, every day. What? How the? What under pressure? I am doing all the work. I am settling the cost title. I am settling the mentioning list. Even though they are not able to bring all the records in the cost list. Yes, what is the matter? Yes. Who is for the state? State, what is the?
My lord, Mr. Mukherjee is appearing for the state. He's stuck in code 38.
What is this instruction? You could have been taken the instruction. They are still preparing the report.
Instruction to remove this police personnel so that the response number 5 can remove their goods because the enforcement directorate said that because of the Supreme Court order, only the CCTV is required to be preserved. That is not in my hand. That is not the building.
My lord, we have faithfully complied with the order of the Honorable High Court so far, Honorable Apex Court so far.
I am not with the Honorable Apex Court. I am here and only I called for, see, Supreme Court has only directed to CCTV footage to be kept in a safest place.
My lord.
Correct.
My lord.
You have done this. So now
My lord, I am for the respondent number 5.
you
I am
state.
the sub-lazy. He is for the state.
I'm just instructed to hand over this report.
But this is not the report.
Let the directly to permit the removal of the goods.
Who is your senior?
Mr. Mukesh Kochi.
Huh?
Cabinet AGP.
You know that this is a matter I fixed specifically. दो बजे आप matter है कि? Come at 2. Tell your senior. And in the meantime, you take instruction. See, only they want what report you prepare. I don't want any report. You have taken the CCTV footage. What for the police require? Why the police required that premises for the?
I'll take instruction, my lord.
Lordship, before I under urgent. Lordship.
Let's call the list.
My lord, in this matter, I appear for the state, my lord.
Yes.
I have approached the electronic complex police station, my lord. They reported that they have captured all the CCTV footage.
What time this inspector will able to come before this court today? What time this inspector will be able to come before this court today? Tell me. Today itself, because 3:30, you have no work. I am here 6:30. Whenever he will get the time before 6:30, I will sit here. Tell me.
I'll call up the police.
Tell me the time.
I'll call up.
This is the way to say, give the report. Preparing the report. And you have and you being the advocate of the state, place the report this communication to the judge.
No, my lord. This is not the report, my lord. They have just.
That's why
it
is maybe in your communication. Can you send the what? See what is the language? It is under preparation. Let the court give some time. What report? What the court ask? What report court has asked for?
The CCTV footage and all that. Yes.
Huh?
And
I have not asked anything. Only I ask what is the necessity of the police in that area now.
My lord. That particular question I put to for the police. They said yes, they have got all sanctions to release the property. That just going to come up with it because some new person has joined. So he is going to give a sanction, give the report by Monday. That's my lord. That's they have communicated. Till Monday, my lord. I will emphasize.
Let the matter appear to Monday at the top under the heading to be mentioned. Please don't do this. You have done before this court not to do this. It is communication between you and the officer.
But I appear.
Yes.
Matter I moved earlier.
My lord, I'm praying for a short passover. The line for the respondent is engaged in court room number 38.
Let him continue engage there. No problem.
Very short point.
Yes.
I tried. The wagon manufacturer.
Wagon.
Wagons are bought by the railways. But my lord, the various wagon investment schemes, by my lord, logistics service providers or the manufacturers. Because the railways, my lord, want to increase my lord freight, give freight, my lord, rebates. So there's a wagon investment scheme, there is my lord LSFTO scheme, which is my lord, the scheme which we are really concerned with. Now, my lord, any wagon manufacturer needs to have my lord, this manufacturing process audited, my lord, under a document, my lord, which is titled as Standards of Infra Manufacturing and Testing and Quality Assurance System, G105. So I refer to it as G105. So, my lord, we obtained, my lord, initial approval, my lord, under my lord G105. My lord, this was on 22nd January 2025. My lord, kindly come to page 33.
Yes.
22nd January 2025, and we see the subject, initial audit of your work at JK Wagon, so and so, so and so. My lord, application, etc. referred to. Then in terms of letters, referred to above, an initial audit of your works at JK conducted on so and so are found to be adequately and satisfactorily addressed. In view of the above, the initial audit of your works at JK so for compliance with this considered as completed. Kindly advise your readiness for a confirmatory audit within 6 months of issue of this. So, my lord, there is an initial audit, and then, my lord, there is a confirmatory audit. Now, my lord, what happens, my lord, after I get this, my lord, and this is in respect of both, my lord, covered and, my lord, open, my lord, wagons. My lord, kindly come to, my lord, Unitech, my lord, which is, my lord, a manufacturer of cement. Sorry, not Unitech, Ultratech, my lord, which is, my lord, a manufacturer of, my lord, Unitech, my lord, is, my lord, real estate. My lord, Ultratech, my lord, which is a manufacturer of wagons. My lord, manufacturer of cement. My lord, needs, my lord, wagons under the LSFTO scheme. So, my lord, it placed an order on us, my lord, valued at, my lord, 23.91 crores on 17th September 2025. Now, my lord, the important thing is, my lord, there's a delivery period mentioned. And, my lord, there is a liquidated damages clause. The lordship will find that, my lord, at page 52. My lord, the purchase order is at page 50. 17th September 2025. Lordship will see it on the right hand side.
Yes.
And, my lord, items are wagon model VCFC M1 type. So, my lord, it's a rake, my lord, which has 59 plus 3 wagons. Your lordship will find that. And, my lord, kindly note this, as per latest RDSO drawing. So, my lord, the design has to be, my lord,
RDSO.
approved, my lord, by RDSO.
Yes.
And, my lord, a brake van also, as per RDSO latest drawing.
Yes.
Now, my lord, clause 3 says, you will complete the delivery of the rake on so and so within 6 months from date of the order. And, my lord, clause 4 is LD for late completion. So, my lord, sorry, my lord, page 52.
Yes.
Clause 3 and clause 4. So, my lord, I am given time, my lord, 6 months. And, my lord, I am requested, my lord, and I'm told, my lord, that if I don't, I have to pay liquidated damages. My lord, this is all that I wanted to show you, lord. Now, my lord, having received this order, my lord, we, my lord, said, kindly extend the initial audit approval, which I just showed you, lordship, my lord, 22nd January 25 at page 30, to cover these wagons. My lord, your lordship will find that, my lord, at, my lord, page 59. Page 59, annexure P5.
Yes.
My lord, kindly take, my lord, the last letter. Further, vide letter referred 1 above, that is, my lord, 23rd September. That's, my lord, straight after, my lord, the purchase order of 17. It's, my lord, item 1. Firm has requested for addition of so and so. Then, my lord, BBCM brake van, my lord, which is also, my lord, mentioned in the purchase order. And BCFC M1 special wagon under category 1, 2, and 3 in the existing initial audit certificate. On the basis of reports submitted by the nominated audit team conforming additional requirement of so and so G105 standard for manufacturing of subject wagons at your works, so and so is hereby granted for addition of so and so. So that wagon, my lord, is included, my lord, in that audit. So initial audit, my lord, they are satisfied with the manufacturing process.
This is December 25.
Yes, this is December 25.
And order is September 25.
Yes, so 17 September was purchase order.
Yes.
My lord, the first letter here is 23rd September. Your lordship kindly sees that page, my lord, 59. Reference 23rd September.
Yes.
My lord, I applied under this letter for inclusion. And, my lord, it was given, my lord, after inspection and, my lord, carrying out the audit, that yes, you can go ahead and do this. Then, my lord, we, my lord, wanted, my lord, what would be, my lord, because, my lord, it has to be as per RDSO design. My lord, we wrote to RDSO, my lord, on 2nd of December 2025, the next document, page 60. Well, last paragraph kindly take note. We mention in the first paragraph the purchase order. Then we say, in view of the above, we request you to provide us the estimate design load charges, drawing approval charges, inspection charges, and other so and so, if applicable for manufacture and supply. So RDSO, it has to be as per their design. Lordship C. Millard, the Millard purchase order. And Millard, V. Millard, RDSO gave a quotation, Millard at page 61. And Millard, V. Millard paid them. Millard at page 62, your Lordship will find, Millard, all the charges are tabulated. Page 62. Millard, kindly have a look, Millard. It's 32 lakhs, 52,080.
Yes.
And Millard, JK Wagons has submitted payments via bank transaction. Complete payment is required as per RDSO during for manufacture. So Millard, we paid them.
Yes.
Now Millard, kindly note Millard and other Millard, very important thing. The next document, page 63. Millard, this is Millard RDSO document.
Yes.
And Millard, here, the Lordship will find Millard clause 2.0. Purpose to inspect and approve prototype type wagons in compliance to para 12.2 of General Standard Specification, revision number 3. Then Millard, kindly come to 4.26. This is very important. Documents to be submitted to zonal office before start of manufacturing of prototype wagon by wagon manufacturer. Millard, request letter, copy of specification, etc. Then Millard, the Lordship will find after Millard subclause A, after scrutiny of the above documents, a letter will be issued by zonal director for start of manufacturing of prototype. Then Millard, kindly take page 70. Millard, we submitted our application, they considered it and gave us permission, Millard, to manufacture Millard prototype. Page 70. Permission for start of manufacturing prototype BCFC M1 wagon. Then Millard, reference above, etc. Drawings would be followed for manufacturing. Above permission is as per RDSO document para 4.2.6, which I showed to your Lordship. For start of manufacturing prototype series production should not be started till approval of prototype wagon and permission for series production from the office. And Millard, page 71, your Lordship will now see there's a photograph. This is the prototype we have manufactured. Millard, one wagon instead of Millard all 72 wagons, because they say don't start line. Millard, let us look at the prototype. Then Millard, kindly come to Millard, page 75. Millard, we Millard requested Millard the railway board for allotment of wagon numbers. Then Millard, page 77. This is Millard, very important. Please refer to your letter in light of terms of permission to procure so-and-so. It is communicated that wagon number so-and-so procured by Ultratech and manufactured by has been unloaded in the Indian Railway Management System. Get in touch with RDSO for further. So even a wagon number is given. So when it operates under the LTSO scheme, Millard, it's Millard all recorded in their digital platform. Now Millard, kindly Millard, see our letter, Millard, at page 78. We confirm, Millard, on 12th of April 2026, that Millard, the Millard purchase, Millard, the prototype wagon Millard is Millard ready. So Millard, we ask for Millard a confirmatory order and Millard a inspection of Millard the prototype.
Correct.
Because I have to supply only Millard after Millard, when they say that that's for their drawing. Now Millard, we Millard write again, Millard on 16th April, which is a reminder. My lord, page 80, my lord, is, my lord, very, very important because now they write and say that they are in a quandary. My lord, why are they in a quandary? Because, my lord, the G105 document, which is a 2011 document, does not mention, my lord, LSFTO scheme. It mentions no scheme. It says, my lord, wagon.
Simplicity.
Yes. So they say it doesn't. So, my lord, what do they say? My lord, kindly come to page 80. My lord, penultimate paragraph. The above LSFTO scheme is different from the scheme mentioned in G105 standards. Therefore, the proposal for inspection of prototype of BC-FMC wagon and conduct of confirmatory audit can be considered only with the approval of the Railway Board in terms of para 1.6 of G100. My lord, they gave us approval under G105. They, my lord, included BCMC wagons, my lord, also under the G105. They gave us permission to start, my lord, manufacture of prototype under, my lord, the RTSO design document. And now they come and say that, well, this is not mentioned in, specifically mentioned.
Is that different from the scheme mentioned in?
My lord, there's no scheme mentioned. I have, my lord, the G105. My lord, kindly take, my lord, G105. And kindly look at paragraph 1.6. It's your document. How long will you keep on concealing from courts? My lord, kindly have a look at, my lord, the copy.
My lord, may I say one thing, my lord?
My lord, I'm giving.
I'm raising the point of territorial jurisdiction, my lord.
Territorial jurisdiction. Yes.
My lord, kindly, my lord, come to, my lord. My lord, kindly note one thing. Time was taken to take instruction on facts.
Yes.
Now, my lord, the submission is territorial jurisdiction. Now, my lord, kindly come to 1.6.
Yes.
Amendment to G105 and migration to amended standard. The amendment to this standard, if any in the future, shall be serially numbered. Normally, 18 months time shall be given to wagon builders to migrate to amended standards, which shall normally be checked through annual verification audits and revalidation audits. All new certifications will only be done to the prevailing current version of G105 standards, amendments to. So, my lord, these are standards to determine infrastructure, etc. There is no mention, my lord, of any scheme. No mention. Now, my lord, we write to them, my lord, page 81. My lord, again saying, my lord, last paragraph, for all these years, my lord, months G105 has been referred to. My lord, kindly take penultimate and last paragraph. It is further submitted that wagons had been ordered under which other approved wagon builders.
Where from you are reading?
My lord, penultimate, my lord, at page 81. This is our response.
Yes.
It is further submitted that wagons have been ordered under the LFT STO scheme under which approved wagon builders are presently manufacturing and supplying similar wagons, with inspections being regularly carried out by RDSO. Now, my lord, kindly note, this fact is not denied. Everywhere else inspection is taking place except mine.
Yes.
Then, my lord, in view of the above, it is submitted that a request for prototype inspection and conduct of confirmatory audit for G105 standard against the aforesaid order may kindly be considered favorable. In view of the above, we request your good office to kindly arrange for prototype inspection so and so along with confirmatory audit at the earliest so that execution of the order may proceed without further delay. Now, my lord, we are 2nd July 2026. My lord, another letter. My lord, 3 months later, they repeat the same stand. Kindly see the existing provision, second para, my lord, of page 82.
Yes,
this
yes.
is letter. refer to procurement under Indian Railway orders or so-and-so schemes prevailing at that time. With the greatest of respect, I've handed up that, my lord, it doesn't say so. And how does it, my lord, deal with their conduct when they include BCMFMC and on the basis of, my lord, the LSFO scheme? Then, my lord, long-term special freight train operator scheme, which is not covered under existing provisions of G105 standards. And accordingly, the matter has been referred to Railway Board for consideration in terms of para 1.6. Further action, so and so, shall be taken accordingly. So they say we referred it to Railway Board. Now, my lord, the time, my lord, to supply, my lord, was extended, my lord, up to, my lord, page 71. Your lordship will find the time, my lord, not 71, 72, please. My lord, kindly come to, my lord, 22nd July 2026. My lord, is the date fixed, my lord, by them, by which time I need to do a confirmatory audit. Now, my lord.
Yes.
My lord, confirmatory audit.
Yes.
And, my lord, the extension of time to supply, my lord, to, my lord, Ultratech was, my lord, I avoid, my lord, in, my lord, the writ petition, my lord, is, my lord, at para 43 is 17th July 2026, which is why your lordship fixed it today, my lord.
Para 43.
43, my lord, may I read it therefore? There is extreme urgency in the matter pertinently respond number 5. My lord, this is, my lord, Ultratech has already been constrained to extend the delivery period and the purchase order on 2 occasions, 17th May and then to 17th July solely on account of delay occasioned by respond number 5. Respondents inaction.
Yes.
My lord, this is the position. Now, my lord, kindly have a look at my averment regarding territorial jurisdiction, since that point is being taken. My lord, paragraph 48. My lord, writ petition, page 26.
Yes.
$48, my lord, kindly.
Yes.
My lord, the petitioners were awarded the purchase order by respond number 5 at their office situated so and so. The petitioners conduct their entire business from their office situated. Petitioners have requested 2 to 4 to take inspection from their offices. Effect of termination shall be felt by rights of petitioner have been overall affected due to illegal and unauthorized steps taken by many events. My lord, kindly note this. Respond number 1 and 4 have their offices within the territorial jurisdiction. Those are the state authorities. My lord, one is, my lord, the Railway Board. My lord, Union of India through Railway Board, my lord, we have, my lord, instituted this. And, my lord, the respond number 4, my lord, is, my lord, part of, my lord, RDSO, who is to, my lord, conduct, my lord, this, my lord,
yes,
inspection. Kindly, my lord, have a look at, my lord, the cost title first, and then I'll show the document. My lord, 2 documents are there. Kindly see the cost title once, my lord. My lord, one says, Lord, Union of India Service to Railway Board, having office at 17 Netaji Subhash Road. Lordship has that.
yes,
And my lord, kindly have a look at 4, Executive Director, Quality Assurance, Research, Designs and Standards at 3 Koilarhat Street, Kolkata. And kindly have a look at, my lord, page 62. First 62, my lord, kindly have a look at page 62. 70, I'm sorry, my lord, page 70. Yes. Kindly see who gave us this permission. 6 March 2026.
Kolkata, yes.
And my lord, kindly see where, my lord, it is being sought to be implemented, my lord, by the railway authorities, page 62.
Yes.
Kindly have a look. My lord, this is, my lord, kindly see who it is addressed to.
Kolaghat. Yes.
My lord, there is a decision also, same point they keep raising everywhere. My lord, 2021 SCC online, Calcutta 4360.
2021
The
is
division bench judgment of our court.
Calcutta number.
My lord, I'll just hand it up. My lord.
What is the number? Page number?
My lord, 4360.
Yes. Yes.
You kindly have a look at this case. But I'll just end up a soft copy. Kindly have a look at para 17 onwards, Miller. Miller, the principle of law in para 17, Miller, print page, Miller, 4.
Yes.
Lordship will find last 3 lines or not. Maintain writ has to establish that within territorial prima facie legal right claimed by him has been either infringed or is threatened by the respondent, and such infringement will take place causing actual prejudice or loss of his legal rights. Accordingly, when the impugned act of the respondent takes effect within the jurisdiction of a particular high court, it may entertain the writ of petition of the person aggrieved, notwithstanding the respondents have their offices or residence. Therefore, whether this court, then Miller 226 Miller is Miller set out, 226 2 Miller is referred to, then Miller para 20 Miller what is part of cause of action, then para 21 each has to be decided on its own facts. Then 22 kindly see. In the present case, no contract whatsoever was executed in between so and so and concern, or RDSO has come on record, or appellant number 1 had to supply the concerned echo or payment used to be made as contained. On the contrary, from the records of this appeal, it is seen that it was required to supply concerned equipment not at so but to 18 zones across and was required to maintain inventory. Appellant number 1 was required to install at concerned, adopting guidelines, etc., etc. Inspect those products, etc., whether it's in the prayer number D made in the writ petition to issue not to take any step against NIT concluding this was tender from such facts. Appellant number 1 used to receive purchase orders from tenders pertaining to several railway zones at its registered comment. Here, Millard, purchase order is Millard by Millard Ultratech, which your lordship will find. Millard, which was placed on us here, and here it was the railway authorities.
Yes.
And Millard, so Millard, here Millard, on that basis it has been held that part of the cause of action has arisen Millard within this jurisdiction. Now, my lord, I would only request my learned friends, considering the stance he has taken, because government has to be fair to court. Now, my lord, I want them, my lord, to, my lord, disclose before your lordships, my lord, a communication of 16 July 2026, after the writ has been filed, by the railway board to RDS, because it's their solemn duty as, my lord, the government, state or authority, that, my lord, they should ensure that, my lord, there is fairness, my lord, in adjudication. I request them also, my lord, to, my lord, disclose this. My lord, I have asked for a mandatory order, but I thought, my lord, on instructions, it could get disposed of. But, my lord, if it is not there, then, my lord, they should extend, my lord, the period for, my lord, completing the audit and, my lord, inspection. Otherwise, my lord, they'll come and say, oh, now the time has expired and nothing can be done after having done the initial audit. And they should produce this communication of 16 July 2026.
Yes. That's all?
Yes, sir.
My lord, that
My lord, if they have it here, they should produce it.
Yes.
well, kindly consider the gist of the facts. That the
Now,
petition,
the communication 16th July you are having?
I'm coming, my lord, before that, my lord, I want to place why I have raised the point of territorial jurisdiction, my lord. My lord, the petitioner, one office is there, my lord, at Calcutta, and my lord, the manufacturing unit at Jharkhand, and my lord, the office of the railway board that is at New Delhi. My lord, the New Delhi, and my lord, all the zonal railways, that is all are under the railway board. So my lord, the everywhere, my lord, from Kashmir to Kanyakumari, now the railway board office may be there.
Correct.
So according to the respondent number 1, that office has shown as, my lord, the Calcutta. But my lord, the railway board office is at New Delhi. And my lord, the RDSO Lucknow, their office at Lucknow. My lord, they are the sole authority regarding the manufacturing and my lord, the inspection of wagons. And the wagon directorate, RDSO Lucknow, they are the sole authority. And my lord, the Kolkata office at the RDSO, they have no authority regarding the inspection or regarding the manufacturing of the, my lord, the wagons. Although they have one letter, my lord.
Yes.
I'm coming on that, whether that letter is a material cause of action or integral part of the cause of action. So, my lord, the order was placed by the respondent number 5, that is Ultratech, upon the respondent number petitioners manufacturing unit of, my lord, the Jharkhand. My lord, my humble and respectful submission that placement of order is itself illegal. My lord, why? My lord, prior to that, my lord, I am to reply, my lord, regarding
You are appearing for?
for railway.
No, RDS or railway board.
My lord, all are
So
railway.
learned friend should indicate, or is appearing for both.
For Union of India. That means, my lord,
You are appearing for all.
No,
Except
then that is
Ultratech.
railway board.
Except Ultratech.
except Ultratech.
Yes.
So, my lord, kindly, and my lord, after that,
My lord, I don't know if Vakalatnama has been filed for all, because it's serious now.
no, no, আমাদের দরকারও পড়ে না। My lord, for Union of India, my lord, Vokalatnama is not required. Our engagement letter is sufficient.
Filed.
But for RDSO?
RDS also given
Yes,
authorization.
yes, all are, my lord, that because, my lord, now they are, my lord, engaging.
Where is our authorization? Have you filed in the court?
No, engagement letter has not filed.
Where you filed? You have to file either memo of appearance.
Yes, because, my lord, we have been engaged by the Ministry of Law and Justice. Now, what happening, my lord? Every ministry of the central government, whatever the legal matters, court case matter, they are sent to the all matters before the Ministry of Law and Justice. And the Ministry of Law and Justice, my lord, engaging their impellent advocate. It is not only for the railway or the RDSO. My lord, all the central government, other ministries also, my lord.
So you are appearing for all.
1 to 4, my lord.
You are instruction.
RDSO and the railway board also, my lord. My lord, our engagement letter is in email, my lord, that is there. If your lordship wants to show, my lord, that I can show from
Yes.
my.
Yes, continue.
Yes, my lord, kindly come to the paragraph 3, my lord. Paragraph 3, my lord. The petitioner is a reputed wagon manufacturer and having its works at PO Mugma PS Nirsa district Dhanbad, Jharkhand. The petitioner is registered as a small enterprise. So, my lord, they are manufacturing unit admittedly at the Jharkhand.
Yes.
4. The petitioner, the G105 initial audit compliance letter dated such and such in RDSO letter dated such and such wagon which stipulated that the confirmatory audit was to be conducted along with any prototype wagon within 6 months. While at that office at Lucknow. Then your lordship kindly come to the paragraph 5. The Ministry of Railway by letter dated such and such granted approval to Ultratech Cement Limited being the respondent number 5 herein for procurement of 1 BCFCM1 Rex for transportation of fly ash. So, my lord, that office of both the office out the territorial jurisdiction of this honorable court. Then your lordship kindly come. The page 77, my lord.
Yes.
My lord, kindly at the top, Government of India, Ministry of Railway, Rail Board. And my lord, their office, that is from my lord, New Delhi. My lord, please refer to your letter under reference such and such permission to procure depositing the requisiting charges communicated via letter dated reference such and such above. Respectively, now it is communicated that the wagon number 62 NOS BCFCF1 with number 1 BVCM wagon procured by Messrs. Ultratech Cement Limited and manufactured. My lord, no, manufactured, my lord, I think why they have stated manufactured because this is manufacturing. Anyhow, my lord, by the Messrs. JK Wagon Limited, LSFTO scheme has been uploaded in the Indian Railway Wagon Management System such and such. It is advised to get in touch with the RDSO for further inquiries in this regard. So, my lord, that letter was also issued from New Delhi office. And my lord, whatever...
To whom it was issued?
Yes, my lord.
To whom it was issued?
Who?
To whom it was issued?
My lord, to the petitioner. That is the Kolkata office.
Then?
And my lord, why I am showing, my lord, my submission is this, my lord, only the merely receiving in communication from another territorial jurisdiction that does not create any, my lord, the material or integral part of the cause of action, my lord. Then you will also kindly come to the page 82 also.
Yes. Page 82.
Page 82. My lord, that is also a communication, my lord, from at the top, my lord, right hand side, Research, Design and Standard Organization, Lucknow. My lord, that authority was issued Director Stan Wagan for Executive Director Stan Wagan. My lord, that letter was also issued from Lucknow to Kolkata office. That is merely an, my lord, the communication received by the petitioner from Kolkata. So, my lord, my learned esteemed friend, my lord, certainly raised the point that from a Kolkata office one letter was sent. My lord, kindly come to the page 70, my lord.
Page?
Page 70.
Yes.
That is the only letter, my lord, which was, my lord, issued from Kolkata office. My lord, kindly see what is written there, my lord. Reference above permission for start of manufacturing prototype BC wagon at Messrs. JK Wagon Limited of Mugma, PS Dhanbad, PS Nirsa Dhanbad, Jharkhand, plant is granted RDSO. RDSO, WPS, QAP and drawing should be followed for manufacture of subject prototype wagon. Above permission is RDSO such and such, para number such and such for start of manufacturing prototype wagon. Only series production should not be started till approval of prototype wagon and permission for series production from this office. So my lord, this Kolkata office,
Yes.
neither my lord, they have approved design or like that, and whatever maybe the inspection earlier was held. My instruction is this, that 3 officer has come from, that was also inspected officer has come from the Lucknow office. And my lord, kindly see one small instruction, my lord. My lord, that was written by Sanjay Kumar, Director Wagon, RDSO Lucknow. The case number G15 certification of Messrs. J.K. Wagon Limited in reference to his writ at Kolkata High Court dated such and such. The Wagon Directorate is the competent authority for dealing with matters related to the G105 certification, including the initial audit, confirmatory audit, inspection of prototype of the development lot, grant of G105 certification, and other associated activities. The prospective wagon builder is required to submit the prescribed application to EDSW RDSO Lucknow for conducting the initial audit as well as the confirmatory audit. The prescribed application forms are available on the RDSO website. The QAM RDSO Kolkata, my lord, that is the related page 70, my lord. The QAM RDSO Kolkata is not authorized to process or deal with the matters pertaining to the G105 standard certification. So, my lord, the Kolkata office, my lord, neither authorized for inspection.
I understand, but the impugn order is otherwise. But the impugn order is otherwise. It is not that it is not the authority and it cannot be inspected. Kindly come to the page 80.
80.
80. Yes, madam. Yes.
Page 80, last paragraph. The scheme is different from so and so. It is not that case. If it's so that, then I am disposing of this red application, extending the time and allowing the petition.
Yes, my lord. Yes, page 80. You also kindly see that letter was also issued from Lucknow.
That's correct. But what is now in this letter, that is not the ground here.
That is not here. Definitely, my lord.
So, in that case, so I will direct, so extend the time and I will direct the petitioner to comply with this letter, this direction. Nothing else. What remains? Yes, Mr. Mukherjee, you are having that. 16 July, which you are asking.
And my lord, in that case, my lord, I'm not against that, my lord. In that case, my lord, because we are appearing on behalf of the authorities. So, my lord, kindly record that I have raised that objection.
I will record that.
I said, no, my learned friend is right. He should have said this first, but then said this territorial. Now,
yes, I have got that, my lord. That definitely there is a territorial jurisdiction. I am also prepared, my lord. If your lordship, my lord, allow us to, my lord, I can produce, my lord, those judgment also, my lord.
See, with regard to the cause of action and jurisdiction, several.
No, I don't think this is, my lord.
I don't think
that is an email communication.
What is the 16 July letter?
My lord, I don't know what
is there any 16 July letter further?
That is the 16 July.
No,
that I have handed over, my
lord.
They are
the same. So they are now taking the stand differently.
It's already happened. All this has already happened. It has already happened.
Certification.
No, my lord.
And my lord, at the very beginning of my argument, I have stated that the placement of order upon the respondent number by the respondent number 5 to the petitioners, it is itself illegal and unauthorized. My lord, why? My lord,
have you taken action against the 5?
My lord, yes, my lord. Prior to that, at the time of placement of order, my lord, when the order was placed, my lord, order was placed on my lord 9 September 2025. But my lord, the ELS FTO scheme order dated, that was my lord inspection, my lord, after that on 17 September. So my lord, that their field verification was not held whether the manufacturing unit was competent to manufacture. My lord, manufacturing is later on.
Who has issued the purchase order?
Purchase order placed by the respondent number 5 to the petitioner. No, my lord, that was not the railway board or the RDSO.
The petitioner, but in conformity with the material.
Yes, my lord, that is not authorized and illegal. My lord, why? My lord, the petitioner unit of Jharkhand, they have no authority to, my lord, to manufacture the wagons. Because, my lord, prior to manufacturing of wagon, there are the various safety and security measures are to be, my lord, complied.
Correct.
My lord, first, my lord, kindly consider when the order was placed on 9 September by the respondent number 5 to the petitioner.
Correct.
And my lord, when their manufacturing unit, whether they are competent to manufacture or not, that inspection was first held on 19 September. My lord, prior to inspection, my lord, the procurement of the order was placed, my lord. How it is possible? My lord, when I have no authority to, my lord, to production of wagon, can I, my lord, receive any, my lord, purchase order?
How?
And my lord, that can be happen when in case of development order. My lord, kindly consider in G105 another scheme, and my lord, that ELS FTO, that is another scheme. My lord, the ELS FTO scheme is not includes in the G105.
I've handed us 105.
105. Can you see that whether there is FTO scheme?
There's any scheme.
Or any other scheme, my lord, because it is a specific scheme.
Okay, if you so that if we go by the impugned order, so where is the other scheme? It is not a scheme.
Definitely other scheme is there.
Which scheme you are asking about?
My lord, kindly.
Whether this 105 is connected with any scheme or
that is a separate scheme.
Where is which scheme?
That is a scheme.
Which scheme? You tell me which scheme. Then we can say, yes, this is not covered under this.
Yes. My lord, kindly see. Kindly see.
This is a general. It is a general standard. It is a general standard, May 2011, and this is a first issue.
My lord, kindly come to the page 82 once again, my lord.
Of the
writ petition, my lord.
Writ petition.
So kindly have a look at the preface.
Page 82, my lord. Second paragraph.
Yes.
The existing provision of G105 standard issues in 2011 refer to procurement under Indian Railways orders of or WIS, MWIS, LWIS schemes prevailing at that time. Since your request involves manufacturing of wagons under the current long-term special freight train operators
Correct.
scheme, which is not covered under the existing.
That's why tell me LSFTO scheme. Where is the scheme which
standard governs?
Standard governs.
That should indicate.
So
yes, my lord.
This LSFTO
scheme.
Correct. So mean that
in LSFTO scheme that is there, my lord.
Correct. Under the LSFTO, what is the standard?
That copy of the scheme, my lord, just now that is not with us.
What is the standard?
Standard, my lord,
what is standard is to be adopted?
There are some different, because my lord, the various types of wagons are there. It is, my lord, flat type or very.
Correct. I am telling. See, 105 is the normal general scheme.
So,
not scheme, general guidelines, whatever it may be. Now you are coming to the LSFTO scheme. LSFTO scheme provides any other guidelines with regard to the wagons.
Yes,
so,
yes,
but
that is
your order
that
does
is,
not also speak so though. Your order also does not speak so.
My lord, that is, both are, my lord, the separate scheme, my lord. My instruction is that is the G105 is also a scheme, and my lord, the LSFTO is also a scheme.
Not a scheme.
It is not a scheme. Show me.
It's a standard.
My lord, what is the long-term special freight train operated scheme? My lord, what is this? My lord, why the
That is
scheme was introduced?
LSFTO scheme, you are telling that, okay. LSFTO scheme, there is any standard prescribed.
Yes, my lord, in that scheme, that prescription was there.
I've annexed the scheme.
Which standard? What is the standard? Show me. And it is not your case. That is not covered under the LSFTO
P3,
scheme.
my lord, page 34. Let my learned friend show, my lord, what standard is prescribed.
I have not stated that the standard is not prescribed. My submission is this, that is the, in different scheme, standard is different.
The matter short. My lord, I asked them to produce a communication from Railway Board to RDSO. Now kindly have a look at what they have produced. My lord, 16 July 2026, kindly see who has signed it. Sanjay Kumar.
Vegan Lucknow.
Your Lordship has that, Sanjay Kumar. Time, my lord, date, my lord, is 16 July 26. Time is 10:11. Director Standards Wagon RDSO. So it's RDSO to RDSO. It is a note, my lord, for the purposes of this. Now, my lord, there is an RDSO document. My lord, my lord, there's a Railway Board document to RDSO on the same date. Now, my lord, my learned friend is not producing that, though he appears for all. Now, my lord, my learned friend will, my lord, I'm compelled to produce it now because of the stand, my lord, which is being taken. My lord, kindly see, my lord, it is digitally signed by Abhay Kumar, 16 July at 1600. After that, my lord, note. And my lord, kindly see who it is issued by. The mother body, which my learned friend said was the Railway Board.
Railway Board. Inspection of so and so.
And now, my lord, this is with regard to our inspection of prototype. Kindly see the subject. And it's addressed to RDSO Lucknow. Inspection of prototype BCFC M1 and brake van wagons and conduct of confirmatory audit of JK Wagons Limited, Dhanbad, under guideline G105. Reference RDSO's letter of 21st April. That's what I placed, my lord, before your lordship. 21st April 2026 at page 80.
Yes.
At page 80. Page 80.
Yes.
Where, my lord, penultimate paragraph, they say the above LSFTO scheme is different from the schemes mentioned in G105. Therefore, proposal for inspection can be considered only with approval of so-and-so. In view of the above, the proposal of prospective wagon manufacturer for so-and-so and conduct and audit is submitted for kind perusal and approval. This they write, they write to Railway Board. Now kindly see Railway Board's response. And my lord, that was written by Sanjay Kumar, who gave that note. Now, my lord, kindly have a look at this document. Neither the, my lord, kindly see at the right, I'm reading. Attention is invited to the letter cited under reference. The matter has been examined in the board's office. In this regard, it is stated as under. Neither the extent guideline G105 nor the provisions governing the wagon investment schemes of Indian Railways contain any explicit stipulation that prototype wagons offered for testing and confirmatory audit under guideline G105 should necessarily originate from an order placed by Indian Railways or under any wagon investment scheme of Indian Railways. In view of the above, RDSO is advised to take further necessary action strictly in accordance with extant provisions of so it doesn't matter whether railway is ordering or it's under any wagon investment scheme, you have to proceed under 105. And this is not being given to your lordship.
Yes.
Well, that letter of date on page 82 of the writ petition, that was also issued by that is relied by the petitioners. My lord, that was also issued by Sanjay Kumar.
No, that's correct. But now 16 the situation
Yes,
is
my lord.
otherwise.
Regarding that, I have no instruction. That is just now, my lord. I have,
You are appearing for the railway board.
well, yesterday, my lord, my lord, 14. I don't know, my lord, why that no instruction was given, my lord, regarding.
You are appearing for the railway board. Railway board is something what remains further.
And my lord, regarding the territorial jurisdiction, my lord, kindly consider.
I will consider, but what about this?
My lord, regarding this, my lord, I have no instruction. My lord, just now I have seen, my lord.
My lord, that's what I said. They have to be fair, my lord. Otherwise, it becomes litigation would have ended. They would have said this letter is there. We go ahead.
So I am setting aside this act in accordance with this letter. That's all. Nothing
So,
remains.
my lord, I have no knowledge regarding this letter. Then I have to take instruction from that Sanjay Kumar also, my lord. What steps they have taken?
Then, my lord,
You take Monday. I am fixing. Land counsel for the petitioner concluded his argument. Land counsel for the respondent argued the matter and also raised the point of jurisdiction. Raise the point of maintainability on the raise the point of jurisdiction of this court. Land counsel for the petitioner has handed over a letter number 2015/M within bracket capital N /951/4 full stop dash part within bracket 1 within bracket capital E dash 3388033 dated 16th August 2026 addressed to the executive director within Baigan RDSO Lucknow by the director ME within bracket Freight Railway Board New Delhi. Full stop. Counsel for the respondents press for time to take instruction with respect of the communication with respect of the letter dated 16 July 2026. In view of the above, let the matter appear on Monday within 5 matters.
And my lord, I don't know how they have collected this letter. It is the internal communication in between the railway board and the RDSO, my lord.
But you should be fair.
My lord, we are a small enterprise who wants to, my lord, enter the competitive bidding. My lord, kindly see what is happening. My lord, my lord, we want, my lord, it's clear, my lord.
Affidavit of that.
My lord, the second service, my lord, affidavit of service.
Affidavit declared. Yes. Next.
Lord, I am doing it by supplying wagons to private end because I can't, my lord, government won't look at me, my lord, because the vested interests are already there.
I'm appearing for the petition. I have been led by Mr.
What is the matter?
It's about appointment. I've made an application for temporary appointment of MMR. The year 2020. Now that has not been considered as of yet. Last, I heard this matter on July 2025, and an order was passed by the state for the state to provide a report, but the state has not been provided as of yet.
By this court? No, it has not come with this court. Where is the order?
Your Lordship, last order was passed by this court on 24th of September 2020.
That's what I'm telling. Where is that?
I don't have the order.
This court has not taken any order. After 24th September, this court has taken the matter. No. Then?
Last order was passed on.
Then what can be? Let counsel for the petitioner press for time. According to cases adjourned, let the matter appear on 14th August. Next. बंद करें.
Original state matter, that's number 8, the appellate state matter, CP urgent matter, is going to open on Monday at 12. And it's a very, very short matter. It goes to the application for the railways.
Motion है
It will take only 1 minute, my lord. I can demonstrate the illegal.
What is the other party?
Other party is Mr.
So now 3 o'clock. Come on Monday. Come on Monday. ये हम तुम लोग कितना लीव फाइल एक साथ रखो उल्टा सीधा करके रखते क्यों? कितना बार तुम लोग को हम गाइड करेगा? लीव फाइल सब एक साथ ऊपर रखो. कल हम 15 बार बोला. यहाँ 2 लीव फाइल, यहाँ 2 लीव फाइल, बीच में अलग फाइल. लीव फाइल फर्स्ट कम. कल हम बोला सब लीव फाइल एक साथ रखो. কি হচ্ছে? मंडे उसको ऊपर रखो. यस.
Matter number notice to the other side. Item number 144. Yes, my lord. But the police sudden and my lord, I being an official documents all time. My prayer is only to open and I will take back my goods. Again, they will put in on padlock, my lord.
So which date?
My lord,
Tomorrow is holiday. I will come. Sunday I will come. Saturday,
no,
Sunday I am free.
my lord, kindly, my lord, subject to lordship's pleasure, my lord, kindly keep it on Wednesday, my lord, as to be mentioned.
Wednesday court is there. I cannot go there to open the law.
No, my lord, they will on your direction because I have made 2 representation, my lord. They are having a hibernation, my lord. So again, that question come, my lord, where will I go, my lord? I have done my part, my lord, and they are, my lord, is.
I am from the authority, LIC.
LIC, yes, my lord. Now they are appearing, my lord.
And if your lordship fix it at the end of next week or any other date.
Why you are locked?
Let them actually the eviction order was passed. And thereafter, my lord, they preferred
Who passed the eviction order?
Estate officer. LIC. This is a case under the Public Premises Act.
Correct.
And they prefer an appeal before the city civil court.
Yes, correct.
That
City
means
civil court appeal.
district judge. District MA. Miss appeal. And that miss appeal was abated. And then they filed a petition for substitution. That petition was dismissed for default. And they, my lord, now filed another restoration application to restore that substitution petition. That is pending before the learned city civil court. Actually, in case of public premises, my lord, only city civil court has jurisdiction.
My lord knows very well, but my lord, only the belonging part.
And then, my lord, in accordance with law, my lord, we have.
If the state officer has passed an order, he is not having the appeal. So how the state officer order is to be executed?
They
putting the lock in the house.
They preferred an appeal.
I am asking one question. The state officer has passed an order. The party concerned has not obtained any order of the state officer. So how you will evict? How you will execute the state officer order? By putting the lock in the room?
No.
No.
When the miss appeal was.
I am asking one question. Give me answer. How you execute the order passed by the state officer?
The execution petition was filed before the estate officer, and it was affixed on the tenanted premises. It was affixed. A copy of the notice was affixed before the on the wall of the tenanted premises.
Correct.
And they
on the date
did
of
not. They are not staying there. They didn't know it. And then, my lord, the estate officer passed an order to execute that eviction order. And in accordance with that order, the padlock was given.
144 को ना 23 तारीख को कोड एप्लीकेशन ऊपर
करो मतलब may it be on 24th, may it be on
24th, my lord.
I'm grateful.
I'm grateful.
Yes, call them.
Lordship, with your kind leave, Lordship, this matter, Lordship, it's a very short matter. My Lord was pleased to fix it on certain days, but it has been my bad luck that it has never gotten a turn to be taken up. I'm not rushing, my lord. I know my lord is very burdened. If my lord would fix it on any date, lordship will not take too much time of my lord. The pleadings are complete, my lord. If it could be taken up for hearing, it's a tender matter. It's a short tender matter, lordship. It will not, will not take too much time of my lord.
September, October, consider date.
Lordship, if my lord could, yeah, accommodate me any day in August.
October,
in August, lordship, kindly.
after puja?
Lordship, may kindly accommodate me in August, lordship.
Huh? 17th August.
17th August, right? I'm grateful, my lord.
Yes.
60.
Yes, call the man.
This is appearing at my instance. The interim order is still today. The case of bank fraud, the only point remains. That the order is admittedly passed by the manager in question and not by the committee. And there are other points not furnishing of the report. But you can hear me today. Per date, I conclude on that part.
Who is for the other side?
My lord. Friend is up.
Tamil Nadu Bank, Mercantile Bank.
Point taken, that private bank read not maintainable. I have already argued and cited judgments.
Well, I have answered, my lord. I have a specific judgment regarding that issue.
Yes, no difficulty.
The matter list has to be mentioned on the prayer made by the counsel for the petitioner for extension of interim order. It is submitted by the non-counsel for the parties. Let the matter be fixed for any date. So the matter prays for non-counsel for the parties prays for fixing a specific date so that the matter can be taken up a hearing. In view of the submission made by the counsel for the parties, let the matter appear on
Any date will not except 24th, 25th. I mean,
18th August
18th.
at 3:45 p.m. Interim order is extended
At
21st of August 2020.
At 3 p.m. if lordship
any
gives, I'll
prior
take
date
by the clock will
Because we are facing the interim order. Any
21st August 3 p.m.
Any prior date, my lord, because we are
Yes,
facing-
21st August.
The order is any event has to go.
21st August at 3 p.m.
I am here. To give me a fresh hearing by the court.
Yes, next.
Madam, where my property was given on rent to the police. They had indicated they would purchase the property. They make us withdraw the appeal, giving the golden handshake. Once we withdraw the appeal, they are saying now, they're not saying anything.
Yes.
So, my lord, my writ petition is seeking a mandamus that they should purchase or they should vacate.
Yes,
Either of the two.
you are appearing.
Your Lordship, I am appearing for the state respondent.
Yes.
Your Lordship, I was only humbly praying if Your Lordship could fix it on any other day.
Today's fixed.
Your Lordship will next week any day, Your Lordship.
Okay, 1 lakh rupees, concert data. Rupees 1 lakh.
Your Lordship, then Your Lordship, let them argue the matter. Your Lordship.
Yes, they are completed. Your chance.
Then Your Lordship, I was not there.
What can be done? You are not there. Every day the state is going to change the advocate. The court cannot hear.
She will
every
only
time.
accommodate us.
I have my notes. If you understand my notes, I will give it to you. If you understand my writing and the notes.
Lordship, let them share the judgments. I was speaking to Mr. Gupta, Your Lordship. He's relied on certain judgments. I'll take those citations. I'll come back next week, Your Lordship, and we'll finish this matter.
But last time was 23rd of June. My learned advocate on record has the noting when there was a change of guard already. 23rd of June, Your Lordship has kept it after a month.
I didn't know, Your Lordship, that they had already advanced their arguments.
No. Nikunj Virilia.
Yes, Your Lordship.
Yes.
Your Lordship, on the last occasion, time was short because we had just been, Your Lordship, engaged for the state work. Lordship, but
what is your good name?
Nikunj Barlia, Your
You
Lordship.
are-
Yes, Your Lordship.
So you had appeared, AGP.
Lordship, I am only seeking a week's accommodation because he's already relied on certain judgments. I don't have those citations.
Give the citation.
And I'll come back, Your Lordship.
Give the citation.
Let him argue on the facts, and I'll give the judgment. And the next day, he can deal with the judgments. I'll give the judgments here and now.
They had asked for the copy of given the 24th June.
बोलो judgment citation गुलो दिए दो. Whatever. Please sending over WhatsApp the PDFs.
The learned counsel for the respondents prays for time to get ready in the matter. Accordingly, case is adjourned. As a matter of last chance, it is made clear that no further chance will be granted if the respondent will not come ready on the next date fix. List the matter on 18th August at 3:45 p.m.
We're going behind by a month.
Done. That is going on since morning.
Your Lordship would see, my lord, even on last 3 occasions this has happened.
Lordship, I am appearing, Your Lordship, for the
Previously, it was the erstwhile advocate taking part in the elections. On that ground, 3 days gone. Now there's a
That's
change
why
of thought,
recorded.
1 day gone.
I have given the rider.
Lordship has said last chance.
Yes, next.
My lord, Mr. Shurjin Das is appearing virtually.
Mr.
May
Shobik,
it please your lordship. Lordship, on the previous occasion, my lord had directed me to answer as to what was done post 6th of August 2025. Lordship, I am armed with the documents of application for the certified copies which were made. My lord will, I will request Mr. Pathok to hand over the documents.
my lords,
My lord will kindly look at the date. It is 13th of October 2025. The application was made for the certified copy of the deed being number 01036 for the year of 2003, which is the subject deed which has been prayed for, whose release has been prayed for by the writ petitioner. The fees has also been paid. Everything has been done, Lordship. As I had indicated on the last occasion also, the ADSR Shialda is unable to locate the deed which they have told to us verbally. However, they are not giving that to us in writing. Lordship, even at the cost of losing the brief, Lordship, I will request if the ADSR Shialda could be added as a party respondent in this writ application, and they can come and answer as to what is the status of this, because they are not giving us anything in writing.
my lordship, I prayed for a short pass.
You're appearing for whom?
My senior is appearing for the petitioner, your lordship.
Yeah, you are appearing for?
I am appearing for the Standard Chartered Bank, Lordship.
Chartered Bank. So,
My lords, only.
what is the prayer?
Your lordship, the prayer, there was
Is for return of that. Lordship, what had happened, if I may recapitulate just in short, the writ petitioner was an employee of the bank who had deposited this deed for the purpose of securing certain loans.
Correct.
This loan has been repaid. That is an admitted position. He wanted return of this deed. Now, Lordship, he had submitted the IGR copy, the copy by which the deed is. He did not submit the deed, Lordship. He submitted the IGR copy. So that deed is still lying with the ADSR Shialda. Now, IGR copy original is not there. We have applied for the certified copy of the deed. The certified copy, Lordship, the ADSR is saying that they do not have a copy of the deed.
So what can be done? If the ADGR is not having the copy of the deed,
Lordship, I am also on the same position, Lordship. We have taken all necessary steps. On the previous occasion, my lord had.
So you transfer your bank in the name of the petitioner. I pass a note, transfer the bank in the name of the petitioner. That is the solution only. If you are not able to keep the document of the borrower in your safe custody, so you are not entitled to keep your property with you. So you give the property to the borrower who has already paid the loan amount, and you lost the copy of the deed of the borrower.
The deed was never given to us, Lordship. The deed was never there with us.
So
He had submitted the IGR, the receipt which is given at the time of registration before preparation of the deed, which is submitted with the office of the ADSR, and then it is then the original deed is given. The original deed was never handed over to us.
But the original deed.
The original deed is still lying with the ADSR Shialda. Now they are saying that they are unable to trace it out and give us.
How the original deed will be with us, ADSR, sir? How you will accept only on the basis of the IGR?
Because he was an employee of the bank, Lordship. He wanted a loan. He was an employee of the bank. IGR, on the basis of that IGR copy, we had disbursed the loan.
Where is the loan sanction file? That will be clear. What the
Your Lordship, I appear for the petitioner.
Mr. Banerjee is for the petitioner.
Your Lordship, I appear for the petitioner. Your Lordship, I have some problem with the video. I'm not able to switch it on. There's some problem I face, but the audio, Your Lordship, I can assist Your Lordship on the audio. Video has some problem. Your Lordship will see the series of orders passed, and my learned pen also submitted before this court that they will take all necessary steps to get back the registered deed, which is admittedly was lying with them on the basis of
the deed was never, Mr. Banerjee, kindly. The deed was never. The IGR was there. The deed was not there.
Means IGR. You know, the IGR means that the custody, that they have the same custody of the document. They have to take the deed copy registered document from the registry office on the basis of the IGR. IGR was never with us. It's an admitted position. They have also lodged a police complaint saying that the IGR was with them. It is lost. Now it is their responsibility, my lord, to get the deed back for me. I have repaid the entire money. That's an admitted position. Now it is their liability. Even under the RBI circular of 2023, my lord will find it's part of the writ petition. It is their liability to return back the deed. I never had the document. So the bank has lost it. Now the bank has to redress the grievance. Otherwise, they're liable to penalty. I'm not pressing for penalty. Your Lordship, 5,000, there is an RBI circular which says that 5,000 rupee per day they have to compensate. I'm not pressing for that. But the
Lordship,
document has to be retrieved.
I have also, if Mr. Banerjee has finished, then I will make submissions. At least from 2015 onwards, when the loan got repaid, at least 10 times the writ petitioner was asked to collect the IGR copy. He did not bother to do it. Today
that's
he
a wrong
comes up in a
submission.
writ
Nothing is on
petition.
record.
No, that is
Nothing is on
I will
record.
let me file an affidavit then.
Why do you
I
file
am
an
trying to
affidavit? You have
resolve
to comply with the
let me
court's
bring this
order.
on record. How many
My lord
times he
will
was
see
asked to collect the IGR document.
a poor person who has repaid the entire
If he has
money is
made
suffering,
allegations,
is
then
not
I
able
have a
to get
right
his.
to counter those allegations by way of an affidavit. Without
You
an
have already
affidavit, I am trying to
admitted, you
help
have filed
Mr.
a
Banerjee's
report.
client over here. He cannot make these allegations
I am not
that the
quarreling with you.
bank
I
is
am
at
not
fault
quarreling
only.
with you. You will see, my lord will see the report filed. They said that they are taking steps for retrieving the copy. Now they have to comply with that. It is on oath.
We have complied. Please, Mr. Banerjee, please ask your junior to collect the documents which I have placed before my lord to show that the steps which have been taken after 6th of August
I am
2025.
making submissions to my lord. Not fighting with you.
155/A, AJC Bose Road, Kolkata. And further to take steps to release the 6 original LICI policies and
LIC policies have been returned.
Your Lordship, LIC policies we have got back.
The bank has
It's only the registered title deed.
That the deed is not with the bank and the bank has applied for certified copy of the said deed before the ADSR Sialda on 10th of March on 13th of October 2025, but ADSR Sialda has not provided the same till date. In view of the above, the petitioner is directed to add the ADSR Sialda District South 24 Pargana as party respondent and to serve the notice upon the ADSR Sialda that the matter appear on 5th August 2026.
Lordship, may I just request for a little bit longer time? I will appraise my lord why I am seeking this, because the bank has to. I will have to release this brief in view of being the additional government pleader. The bank has to make arrangements for somebody else.
Let them take instruction. Let them take instruction.
My lord,
Lordship. Very well, lordship. Very well, lordship.
My lord, humble could it be possible anytime before 5th, my lord? Only my learned
I was also humbly praying for that. Before 5th of August, any date, because your Lordship will see the writ petition pending for such a long time. Series of orders passed not complied with.
No, this is the wrong submission. Mr. Banerjee, series of orders not complied with, lordship. This is wrong. Lordship, such submission shouldn't be made in view of the documents which I have submitted to it.
Before your Lordship, Lord, is the holder of a right to erect structures over the ultimate roof of a multi-story building, in respect of which, my lord, a Form A has been, my lord, submitted clandestinely, my lord, under the West Bengal Apartment Ownership Act, and that purported Form A appears to have been sanctioned or approved on that day itself, giving rise to a certificate of recording of under the Apartment Ownership Act.
I'm for the state.
How am I aggrieved? I am aggrieved because I hold, in terms of a registered deed of assignment, a right to erect structures over the ultimate roof.
Yes.
Therefore, the ultimate roof of the building could not have been a common right. But that has been shown behind my back and contrary to the record as a common feature in the purported Form A. Now, my lord, there is another vital issue. The building in question, the B+G+25 building in question, was required to be blessed by a completion certificate or occupancy certificate granted by the Kolkata Municipal Corporation as a precondition to the filing of a return under Form A.
There's a circular to that effect also, and the purport of the statute is also that. However, shockingly, only on the basis of 3 purported incomplete partial completion certificates which are time bound, that means it was said there that the completion certificates partially for 3 portions are for a period of 1 year within which the actual completion will have to be taken. On the basis of that alone, the Form A has been accepted. We say that accepted, it appears that accepted on the same day as it has been handed back for registration, and in connection with that, a registration certificate has been given. I am agreed because there are suits pending in which, my right is under question. I am in fact agitating my rights.
So what is the writ petition now?
The writ petition is about cancellation of the proceedings under the West Bengal Apartment Ownership Act for 2 reasons. Number 1, the competent authority was under an obligation to accept the return only after the full completion certificate has been issued. Without that, he could not have accepted it. That's a jurisdictional bar, number 1. Number 2, when he took the return, he is under the statute under an obligation to examine and find whether the contents of the return are true and correct. That he has not done, because from the certified copy of that return which he has sent back for registration, it appears that on the same day that the return was submitted to him, on that day itself he has allowed that. And if he had gone, if the competent authority had gone into the question of whether the roof could have been said to be a common area in the given facts and circumstances, each and every deed of the component flat or apartment owner shows that that roof had been set aside or set apart for the purpose of an exclusive area which has ultimately been given. This is not fraud on the owners. The owners in their respective deeds have that covenant, which definitely was either suppressed or the competent authority without application of.
So what is the suit for?
The suit, my lord, is there are, I think, there's a suit pending regarding my right to construct on the roof, in which I am armed with a registered agreement saying that I have a right to. Now, behind my back, this has now gone in. Behind my back, this particular thing has happened, despite the other side also knowing that we are embroiled in a civil dispute in this. So, my lord, regarding the West Bengal Apartment Ownership Act, I am raising 3 points that I have raised before your lordship. Insofar as the effect of the certificate is today, good, bad, indifferent, it can be shown to all persons concerned, including in the suit, saying that because of this certificate, the purported Apartment Ownership Association has rights in respect of the entire building and premises, including the roof, which is the subject matter of my acquisition by virtue of a registered document, a part which had been carved out from each of the owners from the very beginning. It's not a subsequent fraudulent handshake with the promoter. A portion carved out from the beginning, which has been given to me, has not been provided, my lord, in the Form A. Once we came to know of this, my lord, of the fact that such a thing has been done, this we came to know in connection with parallel writ proceedings, in connection with sanction of a plan. I have received, my lord, an order for sanction of a plan over and in respect of that same building. There, my lord, we came to know that this has happened. We wrote to the competent authority saying, please let us know what was the Form A. Please let us know what other document was submitted to you at the time of consideration. We have only been met with silence and darkness. We have, however, got from local brokers 3 temporary possession certificate, completion certificates which are provisional and time bound, each of which has expired before the date of the order being passed. Therefore, on the face of the record, we can show, my lord, that the authorities are active without jurisdiction. There is no statutory remedy of appeal available to me, because under the, my lord knows that under section 10A4 or 10A3, the appeal lies against a person who has applied for registration but has failed. So if there is rejection of registration, appeal lies. But if I am a person affected by the registration, there is no remedy of appeal. So therefore,
well, as the state, I have, my lord, one submission to make. There is no scope of an interim order. I would like to, my lord, your lordship has heard, my lord, the facts of this case are extremely myriad, and it is not, my lord, as if a writ jurisdiction is being invoked, where, my lord,
1 day.
Where is the impugn order?
Kindly see. दिखाओ order दिखाओ. Certificate दिखाओ. हाँ? Page. আমার বই তো কি আমার ওটা page. Please come, Lord. Huh? 219, my lord, is the order. Please have a look at page 219. This is what has been granted, and this is in the public domain. 219 is a certificate of the West Bengal Housing Department, issuance of registration certificate in terms of Form 1 made by the association, and page 220 is the certificate actually granted, registration number such and such. By this today.
So what stay you are praying for?
I'm asking you, Lord, for a stay of this certificate, because otherwise, let them not give any effect or further effect. This creates tremendous prejudice to me in the pending suits. Prima facie, it will be considered that the West Bengal Apartment Ownership Act has engulfed all the rights over the roof in respect of the apartment owners, which is not the case. I had a carved out right over the roof from the very beginning.
Who are you?
I am a person who wants to develop over that particular portion. Okay. Development with excess FAR is possible. That has been given to me by the promoter by a registered instrument. And the promoter had carved out that right from the owners.
Who has filed the suit?
The suit has been filed by some of the owners alleging that they have rights over that roof.
You are also party in the suit.
I am also a party to the suit.
So,
yes.
You could have been filed application over there.
In that suit, not in that suit. West Bengal Apartment Ownership Act is not under consideration. 1, 2. West Bengal Ownership Apartment Certificate cannot be touched in a suit. It cannot be touched in a suit. There's an ouster. Under such circumstances, not the only thing that I'm saying is that this not be given any effect to until they file a report. Have a look, Lord, kindly see what is the effect of this. There is a clear clause, my lord, if your lordship sees the original development agreement, clear clause at page 142 saying that right was reserved. Now by this has been, my lord, submitted to the jurisdiction of the act by certain persons who have kept me in the dark, despite the fact that I was a known defendant to them in the suit. My entire prejudice with this is, my lord, today they will come and say that this is a common area.
How the registration certificate can be stayed, sir?
My lord, kindly let them not give any effect or further effect.
Why?
And only for one reason. Let this not be used as an evidence contrary to my contention by a registered deed that I have rights to develop over, my lord.
Develop. If you're not allowing to develop, you go and take a how you can press the association. No, the registration certificate be stated, then you will allow me to participate.
Only what? May I try to make myself clear on what I want as an interview.
How a developer can restrain the owners association to not to have it for registration certificate?
He cannot. But this is where, kindly hear me for 2 minutes. An association can be formed pursuant to registration under the Apartment Ownership Act.
Correct.
Under the law, this can only be done in respect of a building which has been blessed by an occupancy certificate granted by the KMC.
Correct.
Today, this building does not have an occupancy certificate granted by the KMC. No, it doesn't.
Why the building is not completed and the allotment has not been made?
Yes.
Allotments or agreements for the purpose of West Bengal Apartment Ownership Act does not mean occupancy certificate. Lord, kindly have a look.
Not even occupancy certificate. The land, the flats have been allotted to them.
The units have been allotted to the respective parties,
and they have registered their association.
They have registered the association as a fallout of this Form A. They have not separately registered it. The separate registration is not permissible. If your lordship kindly see section 10A just once.
Why they are not? The association cannot be registered.
No, without Form A,
it's under West Bengal Apartment Ownership Act.
Under the Apartment Ownership Act.
We are the owners of property. You are the owner of
the I'm answering the query of the Honorable Court. My lord, kindly take it from me. A registration of a flat, of a project under the West Bengal Apartment Ownership Act 1972 cannot be done unless the return in Form A that has been submitted under 10A is approved and sent back by the authority to the declarants for the purpose of registration with the Registrar of Assurances. It is on and from that day that they can say that a valid association can be formed.
There is no scope under the statute for any prior formation of association. And that is where it is pinching me, because as far as the association is concerned, if they're managing their own flats, I have no issues. I don't want to step into that.
Okay.
But insofar as the registration is concerned under Form A, it declares a portion of the roof, the entire roof, to be a common area. This declaration is divorced my interest by a registered instrument.
Where is that?
Please have a look at the document. Please not bears with me. Please come page 41, my lord, of my lord's brief, volume 1. I'm so sorry, my lord. This is my registered agreement.
No. In the registered certificate, the portion has been described. Where is that? There is nothing.
No, the registration certificate pertains to a Form A where the portion has been described as common. The registration cannot happen divorce the property. Please do not kindly see your page 41.
41 is the deed.
Registered agreement.
Correct. If you did, you go to the civil court.
I am
yes.
The difficulty is the civil court cannot today. The civil court cannot today, my lord, interfere with the proceedings under the West Bengal Apartment Ownership Act.
Not ownership. Not ownership act. You want to execute this.
I want to implement this. My remedy is suit.
Correct.
There I am not saying that your lordship will interfere and make my remedy fruitful here in writ. No. Insofar as the proceedings that have taken place under the Apartment Ownership Act, according to me, they are bad on 4 counts. 1, before occupancy certificate, under their circular itself, it says you cannot submit a form under Form A. They have done that. Number 2, in that Form A, they have mentioned the roof as a common area, whereas roof belongs to me, and that suppression or misrepresentation they have made on record. Number 3, as far as my lord I am concerned, I was a person interested by a registered document. Registration is public notice. Despite that, I was not given an opportunity of hearing. Number 4,
kindly come to the 219.
Yes.
How you are affected?
219.
Yes, kindly come to 219.
Yes.
How you are affected with this order?
May I explain to your lordship? Your application contained in Form 1, your lordship has seen 219, is a digitally signed soft copy of the registration certificate.
Correct.
Now, this registration certificate is at page 220.
Yes.
This registration certificate at 220 is the fallout of a declaration in Form A, which has to be submitted under Rule 10.
Where is the Form A?
Please have a look, Lord.
Where is the Form A?
We have occupancy.
Please have a look. No, he doesn't. Please have a look. We've checked up. He doesn't.
182.
Please have a look at page 182, my lord, just once.
178 থেকে ওগুলো কি?
182, would you like to kindly see?
এই দেখো না 178.
They are finished.
Partial company good enough.
No, not good enough. I'll show. Yes, for that he has to be assisted by reading the facts.
Judgment of
Let us have
It is that it is good enough. It is possible for.
no, this is
the entire trouble. When the state comes in,
judgment of this honorable court.
Please see the judgment later. Let me first show your lordship where it is pinching me. Please have a look at 182.
Paragraph 45 says.
Yes. Mr. Chaudhary will definitely. You will rejoin all that. Kindly see your page 182. This is a declaration under section 2, read with section 6. If your lordship kindly sees, description of the common areas and facilities in respect of each building.
Which?
Yes. My lord, kindly come. Please come to Lord 183.
Yes.
A, 2A, description of the property. Number 1 is majority of owners have furnished, not all the owners.
Yes.
Now kindly see. The copy of, I'll show you lots of the fraud. The copy of relevant completion certificate is also appended herewith and marked as Annexure C.
Where from you are reading?
Page 183. Top, second paragraph. So this is one of the appendages, my lord.
The copy of the relevant completion certificate is also appended herewith and marked as Annexure C.
Okay, so these registration certificates that are, the completion certificates that are mentioned are present, my lord, at page 178. Please come to 178 just once.
Document pay.
Please come to 178. This is one of the 3 completion certificates. Partial completion certificate.
Yes. Partial completion certificate.
Please see for 1 year only. Building particulars, my lord has seen. Building particulars.
Yes.
G plus 25 story.
Yes.
Kindly come to the second last slide. So and so, so and so, so and so, regularized as per so and so.
For 1 year.
Yes. This is for 1 year. And then kindly come to the next one. This is also, my lord, page 179. Please see, my lord, at page 179, building particulars for 1 year only. Page 180, the third completion, partial completion for 1 year only. Please see their respective dates.
Yes, 1 year because it has not been totally completed.
Yes, so therefore they are given a partial occupancy of certain portions subject to completion plan being obtained within 1 year.
Correct.
That 1 year has passed long before they are put in the application.
Correct.
And therefore, my lord, when they say that I am protected or armed by a completion certificate, it's a fraud on the authority. They ought to point it out, they have not pointed out. One. Second, if your lordship kindly sees, my lord, page 183 first, description of the property. Your lordship has seen description of the property.
Yes.
3 capital A, 2 capital A.
Yes.
Now, my lord, kindly come down to C. After capital A, there's a small a. Then there's a Roman 3, area and description of common areas and facilities. Kindly come to C. Other common areas, if any, lobby, lift, so and so, swimming pool, gym, lounge, spa, home theater, AC hall, multi rooms, common toilet in ground floor and security room, AC sitting lounge, CC monitoring room, full roof. Full roof. So this has been declared as a full roof.
Yes.
Now, on the basis of that declaration, the authority is required to do what? My lord will find in section 10 capital A. Please have a look at 10 capital A of the Act. Capital A, if your lordship sees section 10 first, is the contents of the declaration. My lord has seen that? This is my copy. Please have a look, Lord, at 10 capital A. This 10 capital A read with section 2 is the declaration. It can be furnished by a majority or all the owners. Now, once your lordship has seen 10 capital A, please have a look at how they are supposed to. 10 capital A1.
Yes.
Any declaration referred to in subsection 2 or any amendment thereto or any instrument referred to under 3 or 4 in the first instance shall be submitted by the sole owner or all the owners of the majority of the owners of the apartments in duplicate within 30 days from the date of its execution to the competent authority along with copies of site plans, etc., as may be prescribed. Now, subsection 2. On receipt of a declaration or an amendment thereto or an instrument referred to in subsection 1, the competent authority shall A. After issuing notice to the parties concerned and after holding such inquiry, if any, as it may consider necessary for the purpose, examine the declaration, the amendment or the instrument as the case may be to ascertain whether, number 1, the property concerned comes within the purview of this act, and number 2, very important, the declaration, the amendment or the instrument is in order. That has to be seen with the registered deeds. Each of the registered deeds shows that the roof has been kept apart for further construction. So, my lord, B, he has not followed. Then comes to C. In case of acceptance, immediately return the declaration, the amendment of the instrument, along with all enclosures to the owner or owners, as the case may be, for registration. This is under the Registration Act. For registration, within 120 days of the date of its return, and after it's registered, side by side, they can form, my lord, an association. Here, my lord, the initial process.
But there is an appeal. Any person agree by a not.
A person agreed. Any person agreed by an order of rejection.
Any person, yes.
By an order of rejection. Limited appeal. Is an order of approval.
Yes. Then
So under such circumstances, my lord, what have been the violations? Number one, the fact that they have submitted this P-horse, the requirement of a full completion certificate, which was not there. There is also a circular on record which I have brought, my lord, which I'll show you, lordships. That circular echoes, my lord, the feelings of the act.
220.
221. Please come to page 221, my lord, this circular.
Yes.
Please see 221, the covering sheet.
Yes.
Please come to 222 now, my lord, the eligibility criteria. Sole, majority or all apartment owners should apply for the service. Documents required. Roman 3. Copy of relevant completion certificate from the local authority or municipality duly notarized.
Page number?
Page 222. 222. Please come, my lord, to eligibility criteria in the middle.
Yes.
Number 1, sole, majority or all the apartment owners should apply for the service. Documents required. Roman 1, my lord, will kindly skip. 2, kindly skip. Number 3, copy of relevant completion certificate from the local authority, municipality duly notarized. May I beg to submit with your lordship with great responsibility. On the day they submitted their 10A declaration in Form A, there was no prevailing occupancy or completion certificate from the municipality. All 3 certificates which I have shown your lordship have expired within 1 year from the date that they were issued.
Yes.
Therefore, my lord, this is a primary requirement, though this is a circular, so they will say it's executive, but the executive is bound by its own circular. There are judgments to that effect. I will not trouble your lordship.
Yes.
So entry point is without jurisdiction. Second, he was required to, number 1, see whether the registration is in order. That means he had to compare it with the deed. He has not done that, because had he done that, he would have seen this clause in the deed. Would your lordship kindly see, my lord? Clause देखो. We've given one of the deeds. Every deed has that. Page
142.
Please come to page 142. I'm troubling your lordship, Lord, but this is important. Please come to page 142.
There's been assigned to
किसी का भी नहीं है. Sure.
We don't have to. We are not party to that.
Yes.
Now, my lord, this is what has been given to me by the owner. In the event of Kolkata Municipal Corporation and other authority concerned permitting in future vertical and horizontal extension or construction in the new building, then in that event the same shall belong exclusively to the developer at its own cost. This right of the developer has been assigned to me, my lord, by a registered instrument. That is that page. Page
41.
Please come to page 41 and connect that with my document. That's the right I have got from the developer. Today, my lord, I have shown your lordship, they have declared this to be a common area of the roof. Merrily gone ahead and obtained a certificate. All this will be used as evidence in the suit. Not only evidence in the suit. Today they can prevent me from getting access to that upper floor because of that, saying that is a common.
Where is that portion given to you?
Yes. Please kindly come to
51.
Page
51.
51 of your lordship's brief.
Yes.
Your lordship, the document starts at page 41. Lordship is looking at page 51, clause I. In terms of the development agreement, the developer has become entitled to undertake construction of 2 additional floors. That is the 26th floor and 27th floor, hereinafter referred to as the additional floors, by availing additional 10% FAR in accordance with the present building rules of the Kolkata Municipal Corporation. The said additional floors will comprise flat 26A measuring 4666 square feet, flat 27A measuring 466 square feet with attached open south face reserved roof measuring 1544 square feet.
This is not completed.
No, this is the right entitlement given to me.
So this is not completed.
This is not completed. I'm yet to put that up. Okay. And they are showing that entire thing to be a common roof.
Okay.
And behind my back, when the food pending, and when my instrument is registration alert was currently Supreme Court has said it's public notice, we all knew. Now the Supreme Court has gone on to say that because it's public or constructive notice under section 2 of the Transfer Property Act, therefore it has an effect as if it were actual notice. That means a registered instrument is in effect an actual notice to all concerned. But despite that, my lord, it has been done. Therefore, my lord, my interim prayers are
Declaration clause. Not expressly mentioned in the
Now, my lord, if your lordship kindly sees, my lord, what my interim prayers are there for, why I am pressing for interim relief.
page 36.
Please come to page 36, my prayers.
Interim.
I have sought a declaration that this Form A and the entire process followed, my lord, be quashed.
Where is the Form A?
Form A, my lord,
Correction, please.
has seen, my lord.
Yes. 182. Form A is 182.
182 of my lord's brief. One that I placed, my lord, before your lordship, which contains the word common right.
So that on the basis of this already done that.
This is the Form A.
Hmm.
This is the Form A. It has been given back after approval, which they have now registered under the assurance.
Correct.
Yes.
On the basis of this, already the registration
Yes,
has been
yes.
done.
And
So
then-
why, what purpose it is by giving any interim order on this form?
If your lordship kindly give me this interim protection, that this will not affect the right, my right, if any, to the roof, which is under sub judice before the civil court, I'm happy. I don't want to interfere with that. I don't want to interfere with the P plus C plus 25 already come up. But they cannot interfere with my right to erect structures over the roof of the 25th floor on the basis of this.
Okay.
Yes. Just 3 minutes I'll take. This Milord property belonged to Mrs. Sehgal, who had given it to Milord, the developer Avani. These parties, Milord, Anirudh Daga, other Daga family members are all people who control Milord Avani. While Milord putting up, this is on Baliganj Circular Road, just next to the military camp, very large high-rise building. In the midst of construction, Milord, the shell was completed. At that point of time, Milord, the Avani went defunct, stopped, Milord, doing anything further. So all the very expensive real estate, each flat owner, Milord, managed to finish and pay for and finish the building. And Milord, they subsequently had completion certificate, everything done. Now everything's regularized, they're occupying. Just before, Milord, it went into CIRP, now it's in liquidation, or CIRP. Just before it went to NCLT, what the Dagas do, and when, Milord, this company is dead, they execute an agreement in favor of my learned friend for 3 floors above from the roof, giving him a right to construct. Now this is not beyond plan. He on this basis goes to the corporation and asks for Milord sanction of plan, etc. Corporation has refused. On this, copy it. I hope you are carrying. To find the second copy. So, Milord, that's been refused. Now there is also a suit, Milord, which is pending, filed by the Sehgals because they are landowners, challenging this document, a completely fraudulent document.
Which document? Which document?
Milord, this agreement which he is relying upon. Please see the prayer. Must be having. So he's out of the property. We don't want him to come into the property. He's the owner of air on top of the roof, which he wants to construct, which corporation has refused to give him. Now he wants to get in. So what does he want to do first? Under West Bengal Apartment Owners Association Act, Milord, you have to file that form and get the thing regular, apartment ownership done, association. So that's been done. He wants to challenge that certificate. What is the ground? No, first he was saying, Milord, no completion certificate. Then, Milord, we indicated your brief has partial completion certificate. Then he said partial completion certificate is not enough. Circular says relevant. I have handed up a judgment to your lordship. Milord, please see paragraph 45.
You are appearing for whom?
Milord, from the flat owners. Huh? Who am I appearing? Owners Association. Respondent number 3. May I just read out paragraph 45? Be that as it may, since Form A provides that a copy of relevant completion certificate can be filed along with Form A liberal construction has to be given to the same, and it may be construed that any relevant certificate having the effect of a completion certificate in respect of the particular portion of the apartment for which declaration is sought would make do as a completion certificate. So we not even partial, half, 1/4, everything works for my portion. And wherever we are, not it is certificate. Next issue, my lord, is he says I have a right on the roof. All of us have prior documents. All my members have prior documents which say I have a right of pass and repass on the roof. Please let me show your lordship our conveyance. 140, 148. This is below 7th schedule. I'm sorry, not deep.
Have a look at that instrument because I can show that in that instrument a right is reserved for the developer. The document which is relying on
your repetition.
No, which is a schedule of a registered instrument.
Yes, 148.
My
Yes.
Don't be suspicious of me.
Not only of him, but yes, of him.
Yes.
148, Milord. Remaining portions of the new building, including car parking space, together with share, land, etc., common area of right to use in common areas, facilities, amenities which shall belong to the developer after providing owner's allocation. Then common areas and facilities, your lordship will see the list. So I have a right of use. So that's why, my lord, it's included. And your lordship will see, my lord.
Where is the top terrace?
It's not there. It can't be there because of page 140.
In common areas.
23.5. 23.5 says terrace belongs to the developer. 23.5 at page 142. Same document. Please have a look at 23.5. I showed you lordship this clause.
Yes, 148, third line, right to use.
23.2, 23.5 at page 142. In the event of court comments or other authority concerned permitting future vertical and horizontal, that even the same shall belong exclusively to a developer. Construction rights.
The right to use in common, it's mentioned.
The corporation's refusal of plan is under challenge, and this honorable court has directed that
all units have roof as right of use in common, not per page 148, third line from the top.
Lifts.
The developers, no.
Lifts.
What lifts?
Where is
the portions of the fifth. This is developers allocation. After Milord sale. Milord, please see the fourth schedule first. Milord, owner's allocation. Owner's allocation. Now, Milord. Fifth schedule is portions of the building is developers allocation.
Sixth schedule is common areas, no roof.
No, Lord, please. 148, fifth schedule, developers allocation. Portions of
developers allocation. That makes
car parking spaces, share of interest in land attributable to developers allocation together with the right shall belong to the developer after providing owner's allocation.
What are the common areas in the sixth schedule? Please have a look. Common entrance, boundary, lift, staircase, lobby, multi room, overhead tank, common toilet, guard room, staging room, banquet hall, gymnasium, spa, theatre, water purification plant, swimming pool, tennis court.
Correct.
Roof, not there.
Roof under KMC Act cannot.
No one says roof under KMC Act cannot belong to anybody. Judgment versus Harish Tandon saying roof under, there is no provision saying that the roof does not belong to anybody. It's only.
It is not yours.
Mr. Chaudhary, just a second.
No, I was arguing.
You were arguing, but I'm trying to assist my lord on the correctness of the document, the correct things to be assimilated. There is, if from here my lord has seen 23.5, my humble submission is 23.5 has carved out the right of the developer to construct on the roof. That is why consciously it's not been kept as a common area. And this ought to have been pointed out. And yet, my lord, will see, my lord, in the return in Form A, they are mentioning the roof to be common. Please have a look at the return.
Milord, may I continue?
Yes.
Milord, kindly see, Milord, 147 at the bottom. Your lordship will see. Roof is nobody's.
Yes, roof is nobody's. Definitely. When you move property, roof is nobody's. Rest in God.
Well, you are not God. It can't rest in you.
Chances of godliness are there.
Milord, please see this from the fourth schedule. Fourth schedule is owner's allocation. So, my lord, 60,000 square feet, etc., super built up area, total sanctioned area. Then, my lord, fifth schedule is developer's allocation, is the rest. Doesn't matter. But it's enough to understand.
Then what about the 142, 23.5?
Yes, my lord, 142.
Yes. Page 142, clause 23.5.
23.2.
5. Page
concern
permitting
extension or construction in the that is shall belong to the developer. Yes, very good, no problem. But have they permitted? They've rejected. I've shown your lordship.
That's correct.
So that doesn't make it the roof, my lord. There'll be a roof on top of that, which will again vest in all of us.
See, Mr. Banerjee want to be in the roof and see the sun and the moon.
I don't mind if he allows my clients to see the sun and the moon to the extent
Now,
that he permits. He's part of the sun or the moon. His difficulty is, despite Milord, there being a clause that this has been carved out of his ownership at the inception, he has suppressed that in the instrument, saying that the
Mr.
entire
Banerjee,
roof is full.
one thing. See, wrongly or rightly, there is a owner's registration is there. Registration will not affect you with regard to see. You wanted that the agreement is to be implemented. You got the right in terms of the 23.5. Avoiding the 23.5, they filed the certificate and got the registration. If the civil suit will allow you, yes, you have a right under the agreement for construction of the second floor on the top floor or on the roof or second floor. You will get the
What
now.
about the authorities? Not I'm asking myself the question. The municipal authorities, when they sanction a plan, once they show this is part of a common area in that declaration,
That's
I'll
why.
be stopped. That moment I'll be stopped. So
No,
this
that's
first you will.
Common area. Where is in the schedule? There is no common area with regard to the floor.
Yes.
The top.
Now
it will never be.
Now what will they say? I'll come up with the answer. Not practically, why do I need an interim order? I'll come up with the answer. Now have a look, Milord, kindly at Form A, the one that they've given.
Yes.
And Form A, Milord, was at page
184.
182.
Yes.
No,
182, Mr. Jody, just a second.
Yes, 182.
182.
Yes.
And 2C.
Please come to 23C. Other common areas, my lord, has seen. 23C.
Yes. Other common area, if any lobby, lifts, a staircase, stairways, swimming pool, gyms, all the and full roof.
So the moment this declaration gets registered,
so with regard to the full, let the full roof will abide by the result of the writ petition.
No, if that, abide by the result of which writ petition I'm asking myself.
Yes.
Abide by the result of which writ petition? The present one.
Present writ petition.
But that will mean that insofar as the writ is concerned, this full roof part will remain until the writ petition remains.
Correct.
Despite that being a mistaken question of
See, writ petition will remain, the full roof will be drained, but the subject to, if they will do anything, they're getting any benefit of the full roof, the subject to the future, you will get the order from this court. Yes, you have a right, and you will get the decree from the civil court. You go and.
I am not seeking in declaration of my entitlement from the writ court. That is
Correct.
not the writ court's domain at all.
No, that's why. That's why now you are telling registration. You have no problem with regard to the registration certificate, only with regard to the full roof.
That they have shown that full roof.
Full roof.
They have shown your lordship an instrument from where it appears that the full roof is not a subject matter of a common area. I've also shown your lordship that
Correct. That's what I'm telling. So that okay with regard to
say this part.
May I now? He's not let me say anything. May I, my lord? Yeah. He's become very passionate about this.
10 more seconds of passion before he takes over with compassion. Just 10 more seconds. Where is the shoe pinching as far as I'm concerned? If that that entire roof thing remains valid as a document, before the corporation they'll go and show that there is no stay of this. Therefore, this is declared as a common roof by the Apartment Ownership Act.
No.
So that part I am requesting, let that part be stayed where the common roof has been shown to be common. Let it neither be common nor be uncommon for the time being. Let that part be stayed so that the civil court or the corporation, they will decide in their own wisdom, looking at the entire deed as to whether they will give sanction or not. Otherwise, by this fraudulent instrument done behind my back, whenever I go and say I need a sanction over the 25th, 26th and 27th, they'll come and say, listen, this is the Form A declaration. This Form A declaration of the flat owner says that the entire roof is a common area. How can you ask for sanction on a common area? You don't have a right to present an application for sanction, rejected. If I go up in writ thereafter, the writ court will say, you found this document to your detriment.
So that's what I'm telling, that let it be abide by the result.
No, kindly stay that part of the common roof part. Otherwise let them maintain. I am not.
Common roof part we stay.
Yes.
Tomorrow anything is required in the common roof. Any construction, any repair, anything is required. What would happen?
That common roof is not a part of the rights. I'm asking myself. It's not a part of their rights. If they have any right which they can enforce.
If suppose common roof is not having right.
Yes.
Top floor, if third person, one person has been allotted. Yes. He is the owner. There will be a leakage. What would happen?
If they have a right if they have a necessary easement, they will enforce it against the owner and get the necessary easement from a civil court.
Where will the owner? Once you have purchased, the agreement is.
I purchased the right to erect. So today this has to inhere in who? The purchaser of.
Now give me 2 minutes. This is unbelievable. Mr. Banerjee, Mr. Banerjee, I had started.
My humble submission is, my lord.
And you said it 4 times. You want to stay. You don't want to abide. We all know what you want. Now let me argue 2 minutes.
Let me hear, Mr. Chaudhary.
Yes, my lord. Kindly, my lord, see the KMC building rules. I can show your lordship why the documents are done this way. Rule 117 of the KMC building rules. Please see, my lord, sub rule 4. Every terrace on the topmost story of any building shall have a common access and shall not be subdivided. Mr. Banerjee, I don't disturb you.
You already do. Today you have not done that.
You never do. You just accuse me. And I never get angry with you. No, I am not getting angry. I never get angry. You're my friend. Now see, West Bengal Apartment Ownership Act. Please see, my lord, the definition of common area. So, my lord, under municipal laws, everybody has a right to go on a promenade on the roof. And under, my lord, section 3D of the West Bengal Apartment Ownership Act.
Yes.
My lord, please.
Yes. Yeah.
My lord, see sub-rule 2, my lord, D2.
Yes.
Foundation, common areas and facilities include D2, my lord, includes roofs. The reason is this, my lord. This is because of KMC building rules. So the rule is that you can't subdivide and sell the roof. Roof of a building is for the he, he's very excitable today.
Mr. Banerjee, see,
I'll give you
proof is there. If you will get as per the agreement.
If I get my rights, I construct.
Of course you will. Who can stop you?
One second, brother. 1 second, brother. If I get my rights, I construct.
Correct.
To get my right to construct, I have to undergo a process of sanction.
Correct.
If in the sanction, the document says at the authority, KMC,
Hmm.
that the portion over which I am seeking sanction for additional construction has been shown to be an entire roof common portion and sanctioned and approved by the Apartment Ownership Act.
May I just
then I'm
2
going to
minutes?
see
2
it,
minutes.
bro.
Mr. I'll solve the problem.
No, you need not. The court will
Mr.
solve the problem.
Banerjee, my lord, is a follower of Rudyard Kipling. His life in this matter is based on if. So if he wins the suit, then he'll go to corporation.
There is no injunction preventing me from applying for sanction of plan before the corporation. So I need
It's been rejected.
Please, brother, that's not a rejection. They could not find the documents in the file, so it's a recollation exercise. Please have your facts proper. Number one. Number two.
No, you have to let me argue.
There is no injunction, brother. There is no injunction.
Learned counsel for the parties have argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on Wednesday.
Not safe.
And thank you, Millard. I'm safe from you.
সেটা তো সারা লাস্টে আমার এটা পৌঁছে দিই
We all tribute.